My lord, with your lord,
Said mentioning.
with your lordship's kind leave, may I be permitted to mention a probate application? All formalities complied with. Lordship has sent down the file for the caveat checking. The caveat has been checked. No caveat has been lodged, and such report has also been made. Your
To be
lordship,
mentioned 10th June.
to be mentioned Friday, lordship.
No.
This Friday.
If you wish, I can put it.
Lordship, the only reason, lordship,
I do not know. If you wish, Friday I
lordship,
can.
kindly, I
But
beseech your lordship.
I think that it should be 10th June.
This Friday, if my lord permits, lordship so desires.
This is your desire. Okay, it fixed to the Friday
I'm
fixed to
deeply obliged, my lord. I'm deeply obliged.
next taco.
Any other mentioning?
Mentioning nahi. Judgment.
Matter for orders item number 1 and 2.
I appear for the decree holder. Lordship, I am for the judgment debtor.
ইসিটা তো In the earlier order dated February 27, 2024, this court came to the conclusion that such payment on account of municipal taxes and surcharges for the relevant period to the fund of Kolkata Municipal Corporation was done by the judgment debtor bank without the leave of the Honorable Division Bench dealing with the relevant matter or without the leave of the executing court, and the same was done at the risk of the judgment debtor. From the order dated December 20, 2016 of the Honorable Single Judge and order dated January 8, 2020 of the Honorable Division Bench, it is transpired that the decree holder is entitled to receive the amount of municipal taxes and surcharges in the nature of reimbursement, and that the observations of the Honorable Division Bench have been reached finality, and therefore, being the executing court, I am constrained to hold that such payment to the Kolkata Municipal Corporation by the judgment debtor without obtaining leave of the executing court or the Honorable Division Bench, which dealt with the matter and directed the executing court to dispose of the matter on certain conditions, is beyond the authority of the judgment debtor bank. Therefore, as the admitted tax liability of the judgment debtor bank in respect of area occupied by it in the relevant premises for the period of 1/9/2006 to 30/9/2011 is rupees 1,26,21,725. The bank is under an obligation to pay the said amount to the decree holder by virtue of the relevant consent decree, which has been clarified pointedly in the judgments dated 20/12/2016 and 8/1/2020 as aforesaid. However, astonishingly, in the relevant supplementary affidavit in para 6, it has been averred from the side of the decree holder that unless the judgment debtor is directed to make payment of the sum of rupees 67,50,000 along with the sum of rupees 22,41,040 on account of interest upon adjustment of the receipt of sum of the bank amounting to rupees 19,81,273 towards reimbursement of municipal tax and surcharges to the decree holder shall suffer irreparable loss and injury. It appears that the said amount was seriously criticized by the Honorable Division Bench in the earlier proceedings, being not backed by requisite calculations. But unfortunately, the said amount has been again claimed by the decree holder. However, as the judgment debtor bank admitted its tax liability to the extent of rupees 1,26,21,725 for its occupied portion for the period 1/9/2006 to 31/8/2011, I direct the judgment debtor bank to pay the decree holder rupees 67,50,000 without interest to bring the matter to a logical end. If the decree holder is entitled to the interest part of the claim, it has to take appropriate steps for recovery. Since the consent decree does not whisper about the accrual of interest on principal sum in case of delayed payment. Accordingly, the judgment debtor bank is to pay the aforesaid amount of rupees 67,50,000 to the decree holder within 7 days from date of this order without fail. List the matter on 13/6/2024 for further order.
Deeply obliged.
এটা নিয়ে নাও। দেখে দাও ওটা, ওইটা দেখো নি, 2 নম্বর টাকো নি।
Deeply obliged.
Item number 2.
Therefore, the order dated December 20, 2016 and order dated January 8, 2020, which disclose that the proposed payment of municipal taxes, etc., is in the nature of reimbursement of the payment already made by the decree holder on behalf of the bank, have been accepted by the judgment debtor by not challenging the same. The judgment debtor wants to agitate the said issue once again in a review application, which can only be done in an appellate forum and not by filing a review application. This is not at all an error apparent on the face of the record. All the judicial decisions referred to by the learned counsels of the parties deal with error apparent on the face of the record. The alleged error as submitted by the learned counsel of the judgment debtor does not come under the ambit of error apparent on face of the record. Furthermore, Rule 1, Order 21 of the Code of Civil Procedure 908 also enjoins, if the options under subrules 1A and B are not applied, the mode of paying decretal dues would be as per direction of the court which passed the decree. In this case, there is no direction that the amount of decretal due can be deposited with the corporation. The orders dated 20/12/2016 and 8/1/2020 have uniformly held that the same should be reimbursed to the decree holder. As the ground of reimbursement of municipal taxes and surcharges in favor of the decree holder has become so sound, there was no scope for the judgment debtor to opt out for any mode of payment excepting payment to the decree holder through reimbursement. The plea of the judgment debtor in this regard is not convincing. Therefore, I do not find any merit in the review application, and hence the review application stands dismissed on contest with a cost of rupees 50,000 only to be payable by the judgment debtor to the fund of High Court Mediation and Conciliation Committee, High Court, Calcutta, within 7 days from date. The instant review application, being number 14 of 2014, is thus disposed of on contest. And in theory,
my lord, one submission, my lord, with respect to my lord,
therefore,
for the my lord, judgment data. So with respect to my lord, order passed in GA3 of 2023, my lord, I pray for my lord, stay of the operation of the order for 4 weeks. My lord.
considered and rejected. Okay.
To be mentioned, item number 3.
Latter. The learned counsel for the judgment debtor has prayed for staying of operation of the order. Stop. The said submission is considered and rejected. Next.
Item number 3.
My lord, in this I seek some accommodation, my lord. It will be taken up here Friday or after.
After summer vacation.
After summer.
This is the matter after summer vacation.
10. Item number 4 and 5.
Again. What happened?
Supposed to file a written notice of submission
I
today.
could not make it ready, my lord. I'm seeking for an adjournment. My lord.
Okay. Along with him, you should file.
One week
Just
after
one-
vacation.
The learned counsel, yes. The learned counsel for the decree holder has sought for an accommodation for filing written notes of arguments. Stop. Please the matter when?
1 week after vacation.
18th June.
18 June.
Worship, the judgments that we have cited should be annexed those to
Yes,
the
it
written
can be.
I am also praying same prayer.
Okay.
Unit number 2A.
Grateful, Your Lordship. Item number 6.
I appear for the petition.
Well, I appear on behalf of the caveator.
It has already been discharged, Lordship. Okay,
Yes.
Lordship has discharged the caveat because
Then-
But I have filed no objections, my lord, on behalf of my client. My lord.
that case probate may be granted, Lordship, in terms of privacy. Last occasion I mentioned, then Lordship said that I will pass the order in the to be mentioned save itself.
So is there any settlement agreement?
But there is no agreement, Lordship. They have simply withdrawn the objection.
So last day department is directed to draw up and complete the order dated 25th April
That
2024.
has, the application has been made, Lordship. Now the prayer is to be order in terms of prayer C, grant of the probate of the will of 19th September 2006 is to be made, Lordship.
So there is a settlement between the parties.
Yes, my lord, out of court, my lord, they have settled.
The learned counsels of the parties have submitted that there is an out of court settlement between the parties. Stop. Stop na diye. And there is no impediment to grant the probate application filed by the petitioner. Stop. Perused. Let there be an order in terms of prayer C of the petition subject to compliance of all legal formalities. That's all.
Yes, sir.
Yes.
Oblige, Lordship.
TS 6 of 2022 is thus disposed of. Eta likhe din. Testamentary suit number 6
of 2022.
2020-22 is thus disposed of.
Item number 7.
My lords, may I please?
Sarkarji, started
My lords,
with
at
order.
the
Yes,
outset,
yes.
at
Yes,
the
come
outset,
from
my lords.
Delhi.
Yes, my lords. Yesterday was my return, my lords. I apologize for the.
Why is your other side?
No, my lords. There is no other side, my lords.
Why is your other advocate?
My advocate on record, my lords,
Yeah.
he's yet to come. Today he's a little relaxed because I'm here physically, maybe.
Okay.
Maybe, my lords. My lords, two things, my lords. My application for grant of probate of last will and testament of Sri Kumar Daga, my lords, who's the testatrix. My lords, I am the executor. Now, my lords, the testatrix has been survived by 3 legal heirs. That is me, the executor, the son, my lords, the wife of the testatrix, and the daughter of the testatrix. Now, my lords, the wife of
Wife of the testatrix.
yes, my lords, my mother
Wife of the testatrix.
is my mother, my lords. My wife of the deceased, my lords, if I may say.
Testator.
Testator, my lords. Testator, my lords, wife of the testator, and my lords, the daughter. Now, my lords, the wife, who's also a witness to the will, has tendered her consent for the grant of probate in favor of the executor. Now, my lords, the daughter did not give any affidavit of consent, and my lords, subsequently, my lords, this PLA was filed on 20th May 2022, my lords. Thereafter, my lords, on 27th June 2022, my lords, the daughter or my sister, my lords, filed a or lodged a caveat with the original side department, my lords, under Rule 24 of Chapter 35 of Original Side Rules.
You have told yesterday that it is Rule 25.
Yes, my lords, caveat was lodged in 24, my lords. Affidavit was to be filed under Rule 25, my lords, within 8 days of lodging of the caveat, my lords, subject to correction. Now, my lords, that caveat was lodged on 27th June 2022, my lords. Now, my lords, that is my pleading in my GA2, my lords. I'll just indicate, I'll show it to your lordships. Now, my lords, after filing of that caveat, they did not file the affidavit in support of the caveat within 8 days, my lords, in terms of Rule 25.
GA2.
Yes, my lords. GA2 is for discharge of caveat.
But they appear করছে না তো ও এইটা না একসঙ্গে দাও তাহলে না তো মুশকিল হয়ে যাবে
7 and 8. My lords, 7 and 8. GA2 is my application for discharge of the caveat.
So how is your other side?
No, my lords, there's no other side. My lords, I'll just indicate.
But they filed.
My lords, I'll show to your lordships. I'll show to your lordships, my lords. On 27 June 2022, they've lodged the caveat. They did not file the affidavit in support of the caveat within 8 days, my lords, as required under Rule 25. Be that as it may, my lords. Thereafter, my lords, the matter appeared after a hiatus of 1 year before this honorable court, a coordinate bench, my lords. Whereby, my lords, this honorable court noticed that a caveat has been lodged at the instance of one of the legal heirs and directed issuance of notice under Rule 26, my lords, of the original side rules by an order dated 20th July 2023, my lords. That order is at page 11 of my GA2, my lords. My lords, may kindly take the order once, my lords.
কোনটা শুনছি আমি তো বুঝতেই পারছি
My lords, GA2, my lords, GA2, my lords. Only GA2.
Yes.
My lords, your lordships have. My lords, may kindly
So
take
you did not serve this copy?
Yes, my lords, it has been served.
Where? Affidavit of service?
Filed. Has been filed, my lords. Master service.
Show me.
Master service. My lords, it has been filed. My lords, oh.
You served notice upon the other side.
Yes, my lord.
No, you served that you are going to move this GA2.
My lords, may kindly appreciate. My lords, for a moment, my lords, I'll bow down, my lords. But let me just show your lordships two things, my lords. After that further notice is required, my lords, I'll serve if your lordship so desires. My lords, may kindly take page 11 of my GA2, my lords. Kindly, my lords.
Yes.
Now, my lords, page 11 is an order dated, my lords, 20th July 2023, passed by Honorable Justice Mukherjee, my lords, presiding over a coordinate bench. My lords, may I just place the order for your lordships? This is an application for grant of probate of the last will and testament of the above named deceased. There is no consent affidavit from one of the legal heirs who would have inherited the property in case of death of the intestacy of the deceased. She has, however, filed a caveat through her advocate, SKR Advocates. Considering the view of the department after scrutiny in the matter, let notice be issued. Now, my lords, this notice may kindly, my lords, take original side rules, my lords, Rule 26, my lords, which is to be issued after if the caveat is not filed. Now, my lords, may kindly come to, my lords, paragraph 7 of my application, my lords, which is at page 3. My lords, may kindly take when was the caveat filed. My lords, paragraph 7, page 3. The daughter filed the caveat on 27 June 2022. My lords, thereafter 8 days she had to file the affidavit. She did not file. In fact, she did not file for more than a year.
So I have to take instruction from the
now, my lords, no.
whether they are
Service has been done, my lords. I'll show the service now.
Yes,
After
sir.
this order, my lords, may kindly take page 28 to 31. My lords, in terms of this order, the department
21.
has served.
21, yes, 21.
28, my lords. Page 28 of my application, my lords.
Yes, 28.
My lords, this is the service on the advocate on record of the caveatrix. My lords, kindly see, my lords, page 28. It appears from the record of this office that as per the instructions of heir of the petitioner on 6/9/23, a photostat copy of the notice was sent by speed post with acknowledgement due for the cited party. by Shri Debashish Mojumdar, one of the sheriff assistants, at the addresses following. And in response, this office has received neither postal acknowledgement nor undelivered packets in respect of the cited party through general office till date. However, computer generated speed post tracking report obtained from official website of the Indian Postal Department informing, my lords, kindly, my lords, take note, item delivered, delivery location on 11/9/2023. So, my lords, this is the advocate on record who has been served pursuant to the order of court in terms of Rule 26. Now, my lords, may kindly take the caveatrix has also been served. That is, my lords, page 31, my lords. Kindly take, my lords, page 31. My lords, the same report of the sheriff. It appears from the record. Now, my lords, here also, I'll just not trouble your lordship with the entire. However, the computer generated speed post tracking report has been obtained from the official website of the Indian Postal Department informing item delivered. So, my lords, almost 2 years have passed from the lodging of the caveat. And two notices have been served, my lords. One at the instance of the court, where a sheriff has given a report, my lords, and I have also served. So, my lords, they are not willing to pursue this matter any
No,
further.
no, I have to check the check from the department's record whether caveat has been filed or
Yes,
not.
my lords. Let me just show to your lordships the department's record, my lords, whether a caveat has been filed or not, my lord. My lords, if I may just place this document before your lordships, my lords, at the request of so and so, I do hereby certify that a caveat with Wakalatnama has been filed with Sangvi on 27 June, my lords, as I informed your lordships, through her advocate, my lords, as I informed, SKR Associates. Address is also the place where the for second notice was served. And, my lords, another caveat. And, my lords, the first caveat is without affidavit. Kindly note, my lords. The second caveat was with affidavit, which your lordship disposed on the last day. My lords, I'll show your lordships that order also, because your lordships found that there is no caveatable interest of a party who's not coming through succession or through will. So, therefore, my lords, the application by PS Group was dismissed. Now, my lords, this first caveat was a sole caveat without any affidavit. So, my lords, therefore, my lords, I am praying that, my lords, the caveat be discharged in terms of prayer A of my master summons, and, my lords, the PLA be treated as a non-contentious matter. my lords.
আসুন এদিকে আসুন। The learned counsel for the petitioner has submitted that one of the legal heirs, what is his name? Sangvi?
Sangita, S-A-N-G.
Sangita Sangvi did not file any affidavit in support of her caveat filed on 27/6/2022. Stop. Notices were issued under Rule 26 of the
Original side rules, chapter
original
35.
side rules, but she did not respond and did not file
Any affidavit.
any affidavit within 8 days as stipulated in the relevant rules. And as such, he has prayed for discharging her caveat, and for that purpose, the GA2 2024 has been filed. Stop. I have gone through the materials on record and find merits in the submission of the learned counsel. I find merits in the submission of the learned counsel of the petitioner. Stop. The report of the concerned register dated 17/5/2024 is supportive of such contention of the learned counsel. Stop. The caveat filed by Sangita Sangvi is hereby is discharged. Stop. Release the matter after summer vacation for appropriate order.
Deeply obliged.
একটা ডেট দিয়ে দাও তো।
Much appreciated.
হ্যাঁ দি thank you. সেভেনটা কি হবে? সেভেনটা what would happen to 7? সেম হবে, একই সঙ্গে হচ্ছে কি?
একসাথে 7 and 8, 19 June, 19 June. অর্ডারটা হলো 8-এর প্রবলেম এইচটার মানে আইটেম নাম্বার 8 এর আইটেম নাম্বার 9
My lord, my application, my lord. For the daughter of the deceased, one of the beneficiaries, I am supporting their probate. I have given my consent in support of the caveat, my lord.
So what?
My lord, the testatrix, my lord, is the mother of the executor, my lord. My lord, the testatrix executed a registered will dated 9th August 2014, my lord. Thereafter, the will was, my lord, misplaced. And she had obtained a certified copy on 31st October 2018, my lord. Thereafter, she passed away, my lord, on 29th January
How she has
2021.
lost?
My
how
lord,
she
it
has
is
lost?
mentioned in the police complaint, my lord, it was
Yes.
misplaced.
I want to know that when GD was filed.
GD was filed, my lord, after her death, my lord, on 27th August 2022 by the executor.
It is a registered will.
It is a registered will, my lord. My lord, in this matter, my lord, citation has been issued. There was an order.
How many
for
legal
issue.
heirs?
My lord, the executor is the son, my lord, and she is survived by 2 more legal heirs, my lord, an older son and a daughter. My lord, after the issuance of citation, my lord, as my learned friend has I am said, for the daughter. the daughter has, my lord, given her consent. However, my lord, the son has not come forward. Um, Citation has been issued, my lord. Mode of service from the office of the sheriff is there, my lord. It was delivered upon the son on 13th of September 2023, my lord. It was returnable after 8 weeks. The son has not come forward, my lord. My instructions are there is no caveat, my lord. So, my lord,
You have to prove the will.
my lord, a
solemn
date has
form.
to be fixed for proving the
The learned counsel for the executor
executor.
has submitted that that the original will has been lost, and for which relevant GD was
One intelligence, my lord.
lodged
My lord,
to the lodged with the concerned police station. Stop. One of the legal heirs is not coming forward to give his consent. However, daughter of the daughter of the testatrix has filed no objection.
I've given my objection. One indulgence, my lord. As per the statute, the copy of the will, the certified copy of the will also acceptable, my lord.
Yes,
The statute says so.
statutes also say that this is a discretion of the court.
Absolutely, my lord. Absolutely.
So only you know only one part of the statute. The discretionary part you do not know.
Will or the copy of the will.
Yes, sometimes Xerox copy is being produced. Yes, I have to accept. You wait for some time, then you will find the revocation applications is coming from. After 10 years, revocation petition will come. Okay.
Legal heirs. I have given no objection. They are the
Okay.
executor and another is.
If the will is genuine, there is no
The registered will.
nothing. Yes, there will be no problem for you. Okay. Only solemn form. Okay. কি বললাম? No objection. Stop. Para. However, as the original will is misplaced, comma, the learned counsel of the executor wants to prove the will in solemn form. Stop. Para. একটা date দিয়ে দাও. In the monthly list of July করে দাও না.
It is the time, my lord, because the witnesses.
Date ঠিক করা যাবে জুলাই মাসে?
Date, my lord.
করে দাও.
My lord,
একটা date ঠিক করে দাও.
kindly fix any date, lordship. Any day in July, my lord, kindly fix.
Yes, yes, no problem. All the attesting witnesses are alive, I think.
Attesting witness is there, my lord. Attesting witness is there, and
July.
executors will also.
তুমি বলে দাও, বলে দাও.
2nd July 12:15
2nd July 12:15. So what is the
Business action on 2nd July at 12:15. लिखा था 2nd July at 12:15. Read through. Item number 10.
My lord, I am for the petitioner in the matter. I am praying. This is regarding an order for grant of probate in the last will and testament. But my lord, in the last order, it has been said that the department has been directed to draw up decree. But my lord, the matter was non-contentious. The decree cannot be drawn up. Therefore, I am praying for amendment of this order to the extent that the reaction upon department is concerned.
এই আসুন, the learned counsel for the petitioner has submitted that a correction is required to be done in the order dated 13th May 2024. Para. Perused. Para. The line on the line the last paragraphs of the said order, which runs as follows, under which quotation: the department is to draw up the decree in accordance with law and rules, unquote, be deleted. ঠিক এটা হলো না, the paragraph containing the lines করে দিন, বলে ওইটা department to draw up the decree in accordance with law and rules, unquote, it will be deleted from the said order. Stop. Para. All other content shall remain unchanged. Okay.
Much obliged.
তো disposed of liberty to mention, but disposed of হয়ে গেছে বোধহয় এটা, দেখো তো disposed of হয়ে গেছে already.
Oh, really already disposed of. ওটা order correction হলো already. তখন 4 মে। Item number 11.
Lordship, I appear on behalf of the decree holder, my lord.
Or is the other side?
My lord, the other side, I had informed you, my lord. It has come up at my instance for correction of the order of your lordship last order, my lord.
With date of transfer?
Yes, my lord. That
Date of release?
it should be deed of transfer, my lord. Instead of that, it has wrongly been recorded as date of transfer, my lord.
আসুন একবার। The order dated 20th February 2024, which was rectified by order dated 16th May 2024, was not properly done, since the words date of transfer, words, ever quotation, date of transfer should be deed of release. Deed of release. Stop. The order dated 16th May 2024 is hereby recalled. Stop. Para. The order dated 20th February 2024 be corrected. Stop. The words date of transfer, এটা কোটেশনের মধ্যে, date of transfer, এটা কোটেশনের মধ্যে রাখলেন, be read as deed of release. Deed of release. Stop. এটা কোটেশনের মধ্যে রাখবেন. All other contents in the said order shall remain unchanged. Stop. This matter on
My lord, it was listed on 26th of June, my lord.
Oh, no problem. এটা প্রথমটা কিভাবে শুরু করেছি? should be read as, আচ্ছা আচ্ছা ঠিক আছে, should be deed of release, হ্যাঁ যেরকম should be deed of release, okay, হ্যাঁ yes. লিস্ট আবার লিখতে হবে, লিস্ট দি ম্যাটার,
এটাই আছে না ও এমনি
না ওটা তো রিকল্ড হয়ে গেল না, ওই ওটা তো রিকল, লিস্ট দি ম্যাটার অন 26 জুন আবার লিখতে হবে,
হ্যাঁ।
আবার লিখে দিন ওই লাইনটা।
execution cases item number 12.
May it please your lordship, I appear on behalf of the decree holder. This is my application for execution. The last couple of occasions, my lord, your lordship had been pleased to extend my time to file my affidavit in reply. It is ready, but it has not been affirmed yet, my lord.
Again,
Kindly keep it any day after the vacation, my lord. We'll do it, my lord. I'll serve a copy in the meanwhile and come back.
what is the decree about?
Give me money decree, my lord.
It's a money decree, my lord. I was a bank. Decree was against different number. They were claiming some money against the judgment letter number 1. But since I was also party, now every burden has come on me because one is not appearing at all.
So joint and several.
Joint and several it was, my lord. But still, I cannot challenge the decree in the executing court. So I paid the entire money, what was according to the calculation. I have filed an affidavit in that score, my lord. My lord, instead, in against that affidavit, they want to use any opposition, my lord.
Yes.
My lord, as per the decree, whatever the calculation, along with the calculation, I have given an affidavit, my lord. But it has been given, I think, 2-3 years back. Till date, they have not whispered. The matter has come and now it has come to.
These are certain facts, my lord, which I need to deal with, my lord, which are in his opposition. My submission is, yes, he has paid some money, my lord, but the entire decretal amount has not yet been satisfied. What my learned friend has done, my lord, I'll tell you, my lord, where the issue is arising, my lord, he has paid certain sums of money. He is
how many times I have given you time? That
quite
is
a
the
few
one.
times, my lord, quite a
Then-
few times. I bow down to that.
Give some cost to the bank.
Look, kindly, my lord, it's ready, my lord. I can serve a copy, advance copy also on him.
Today, you please serve it today in the course of day.
I'll try and do that, my lord, today.
Okay.
I'll try and do that, my lord. Kindly fix the matter after the vacation. Any day, my lord, I'll be before your lordship.
For unnecessary, my lord, I am being troubled, my lord, always, my lord.
I am the one being trouble having to come and execute it, but let me not
Learned
get into that.
counsel-
Let me wish my learned friend a
Hey, Asuna,
happy
Asuna.
holiday.
The learned counsel for the decree holder has again sought for accommodation. However, he undertakes that affidavit in reply or
Affidavit in reply, my lord.
affidavit in reply against the affidavit filed by the judgment debtor.
Judgment number
Bank,
2.
Judgment debtor number 2
Indian Bank.
in course of the day.
My lord, kindly make it Friday, my lord, by Friday. Day
By,
after.
by Friday. By Friday, আজকে ডেটটা ফ্রাইডে ডেটটা দিয়ে দেবেন 24. Please the matter after vacation when you will be available, sir.
My lord, after vacation, I am available.
একটা ডেট দিয়ে দাও তো দুজনের সুবিধা মতো।
কত করবেন 17 জুন।
Thank you. Most grateful, my lord.
চলো অর্ডার ফরের তো করে দাও। Item number 13.
But I am for the decree holder petition, my lord.
My lord,
This is the matter.
Commissioner of Partition requested me to pray for an adjournment and fix the matter after vacation. Any day, he shall be personally present before my lord.
That I cannot
Any
any objection. But the only thing is that my lord, learned partition commission, he has given another letter by my lord demanding the rest of the amount. My lord, the parties are not in a position to
Let
pay.
him come, he shall consider, okay.
Kindly release us, my lord.
Hey, the learned counsel appearing for the learned partition commissioner has sought for an accommodation as the learned commissioner is not available today. Stop. Please the matter
14 June.
হবে
14
14th June. Okay.
Friday. হ্যাঁ আইটেম নাম্বার 14
হ্যাঁ
My lord, can you see my lord's last order? I hope they've got the particulars today.
My lord, we have
Your
received a communication of the order. My lord, I am for the judgment debtor. My lord, may I be served with a copy of the execution application?
We have tried you level this.
We have
They
served
have
already.
tried. Already they have taken steps, but you are not appearing. What happened?
They are to intimate today where the monies are kept.
Yes, the
My
place.
lord, may I be served with a copy of the application?
Order comply করতে হবে তো।
My lord, we'll file an affidavit to that.
I'll be seeking their personal after a judgment letter. Then I shall be asking for the if they are refusing to disclose the particulars.
You are appearing on behalf of whom? Judgment debtor.
My lord, I'm for the judgment debtor.
So these are decree dated.
Decree dated 6th of October 23. We have served. We have moved after service. We have not. So this is within 2 years. Oh, within 2 years, we moved ex parte. After that, we have served twice over. In fact, I have got the earlier affidavit of service. Or she kindly sees the affidavit of service affirmed on 30th May 2024. 3rd May 2024. But she kindly sees page 3 of this 3rd May affidavit. Page 3.
So in spite of
16th April, this has been served by registered speed post delivered, what you will see page 4 on 18th April, along with the execution petition served on them. Over a month. So after, my lord, we served once more, my lord, on the last day's order, the affidavit service now. Can you take a look at the last day's order? We have served again on 16th May. The 15th May order, 16th May served, received by them.
So 15th April order
has been served on them on the 16th of April.
Have you gone through the order?
My lord, I have received the order.
Yes, he has the order.
Then
My lord, I will file
no,
an
no. When your client received that order, I want to know from you.
My lord, my client has received the order. We have got information on the last week, my lord.
When?
The first order was served on 18th April.
Then
My lord,
how can I help?
client.
How can I help a litigant who did not care for my order? Tell me.
My lord, kindly gives me time to file an affidavit disclosing the particulars of the bank account.
File today. Take instruction. I am here till 4:30.
My lord, kindly keep this after vacation, my lord.
You take instruction that you have kept. You have complied with the order of this court. You have to submit that. Yes, I will. If I do not, I will. You undertake. I can allow your prayer.
My lord, we'll file an affidavit to that, but disclosing the particulars of the bank account. My lord, kindly keep this any day after vacation.
No, not. Yes, what can be done, Mr. Mitra? What can be done? Yes, sir.
Keep it on Monday, lordship. Let them come and on Friday, my lord is sitting. Or you keep it on Friday. Kindly let them come and disclose. Give the particulars.
You bring today itself.
My lord, my lord, kindly keep this after vacation, my lord.
After vacation, lordship. If they twice orders passed for the same relief. Today, if not lordship, in case lordship is sitting, or you can keep it on Friday. Sitting. So then
10th June. Okay.
Lordship then
10th June. Reopening on the day of reopening. The learned counsel appearing for the
record that they will. They have said that they will give it.
The learned counsel appearing for the judgment debtor has submitted that they will file an affidavit and you will comply the order.
My lord, we'll comply the order. My lord, kindly can we keep it on 11th, my lord?
Yes, but I have to record your submission that you will you are undertaking that your client will comply this order.
Comply the order.
Have you submitted Vokalatnama? No.
Vokalatnama is not submitted.
Then how can it be? You have to file another undertaking. You have to submit another undertaking that you will file Vokalatnama. If you do not have any Vokalatnama, how can I pass appropriate order against judgment debtor?
My lord, we'll file the Vokalatnama along with the affidavit.
What is your name? ওনার নামটা নিয়ে নাও। Otherwise, I shall take appropriate steps. ওনার নামটা নিয়ে নাও। কি বলো? লিখুন। কি বললাম? That he will file an affidavit along with Bhokalatnama on the day of reopening, and further he undertakes that the judgment debtor shall comply with the order dated 15th May 2024. No, 15th April 2024. Okay.
The second order, Lordship, will see
Yes,
also.
15th April.
And 15th May. 15th May was the second order where
15th April and 2024 and
15th May.
15th May 2024. Orders for them. Okay. List the matter on 11th June.
Hello. Item number 18.
My lord, I'm opposing this application. My lord, I'm only seeking for some time to submit our opposition.
18.
Last order.
What do
My lord, as I understand, my learned friend is not opposing
No, I am
this
not
prayer for
opposing.
extension.
I am
my
not
lord.
opposing, my lord.
I do not understand what is going on.
My lord, this is an application for revocation of the grant.
Who
The
filed
grant-
this? Who filed this revocation petition? You.
my
They
learned friend,
supposed to file, my lord, opposition on the last order that Lordship was directed.
and I'm opposing this application. They have filed this application seeking revocation of the grant. The grant was made in favor of my client.
So you want to file affidavit in opposition?
Yes, my lord. My lord,
But I have already, you are not there. In
my
spite
lord,
of that,
on
I
the
am.
last occasion, my lord, I tender my apology, my lord,
When?
unconditional apology, my lord. I was under personal difficulty that day.
Oh.
And my advocate on record, my lord, she did not contemplate that it would be taken past 4:30.
4:30.
Yes.
After 4:30, this order was passed. How?
How it can be, my lord?
That's she's
How it
here.
can be, my lord?
She's here.
Nobody was here, my lord, at that point of time.
I could not ascertain, my lord, whether the matter will be taken up or not. But I left the court.
Okay, no problem. Sir,
Yes, my lord, I'm humbly seeking some more time, my lord. Since we are due to close for the vacation, my lord.
yes. The learned counsel, the learned counsel, opposite party.
Found, my lord, the letters of administration has been granted in favor of my client.
So petition. Petition is
Opposing-
little confusing. For the propounder, oblique respondent in GA3 2024 has sought for an accommodation for filing affidavit in opposition against the revocation petition. Stop. So it will be convenient for you 13th June,
My lord, 30th June,
13th.
13th. Some more time, my lord. The except
Ajay,
the first week,
affidavit in opposition be filed within 17th June
deeply obliged, my lord. Deeply obliged.
2024. Stop. Affidavit in reply, if any, within 7 days thereafter. Please the matter after 3 weeks from summer vacation. Okay. At a date.
And my lord, one small prayer may I make, my lord? Kindly come to page 69 once. Page 69 of the my lord, my application. Once, my lord.
Why?
Let them know, my lord. Because my lord, it's a technicalities, my lord, which they have to, my lord, comply.
Hey,
So that should be in their affidavit, whether that has been complied with or
That will
not.
come out, my lord. All those facts, my lord. I am not going into any contentious matter today, my lord.
Okay.
Let us, my lord, let us file
only-
that
No, my lord,
affidavit,
only
my
page
lord.
69, my lord.
69
Only page
years.
69, my lord. Kindly see the last portions, my lord. So, Mayapur. Now, my lord, will named effect with so. He said Sattaraj Das having undertaken to administer the said property and credits and to make full inventory thereof. The exhibits in this court within 6 months from the date of issue of this grant within such a further time, my lord. Whether that has been done or not, let them also explain in their affidavit, my lord.
Then if you seek their they should file 6 months within
That
then
grant has been
then grant is correct one.
Lord, I am not on that, my lord. I'm not on that. This is a
You
order,
should
this is
not-
the order of the court.
should
May
not-
I will
should
satisfy.
not praise upon
I will
this.
satisfy.
Okay, it would be it may be an additional ground for you.
Lordship.
Okay, আর কি আছে? এখন আছে?
Get
Item number 19.
My application for revocation of letters of administration granted to a class 2 heir, Lordship. I am also one of the class 2 heirs. And without citing service of citation upon me, the petition has been filed and thereafter the letters of administration will be granted. Lordship will...
Paper publication was not done?
Nothing, Lordship. In fact, the genealogical table was incomplete. And the it has been filed, Lordship, without suppressing the fact that I am alive. One of the other
How
class
do you
2
get
heirs.
this information?
Lordship, recently at a
Recently.
now the other
When the grant was made?
Lordship, on 27th of 20th of July 2023, and Lordship, in the
20th
meantime,
July 2023.
yes, Lordship,
Yes.
in the meantime, after few months of the grant, the administrator expired.
Oh.
And thereafter, the son of the administrator has, administratrix. She's a lady of 89 years, I'm told. And even in the effort of verification portion of the application for letters of administration, she has deposed that she is 89 years old. And in spite of that, she was bedridden. And in spite of that, the grant was made and without citing me. Now, thereafter, recently I've come to know the son of the administratrix, after her expiry, is claiming to be the owner of all the assets which are forming part of the affidavit of assets in the application. Now, immediately I have taken an inspection. I have come to learn there are additional affidavit of assets were made with the leave of the court. Certain assets which do not form part of the estate of the deceased were made part of the estate, and thereafter he is enjoying the entire property of joint family property.
A serious issue.
Yes, Lordship. Now, Lordship will kindly take my application very, very seriously. First of all, because the administratrix is no more alive. In any event, a fresh application needs to be made upon service
So
notice
that
to
the
me.
additional property was amended after grant was done.
Lordship, before the grant was made, a leave was taken to add further assets to the estate. Now, those assets, along with the earlier, which formed part of the affidavits of assets, everything. There are jewelry, ladies' jewelries in the locker, Lordship, which has been enumerated, and he was a bachelor. The deceased was a bachelor. Now, those jewelry cannot be his. It was his mother's, and the entire family is entitled to those
What
jewelry.
is the relation between the
Now, Lordship will kindly take the genealogical table first of all, which is appearing
GA1?
page 40. Yeah, no? Now, Lordship will see the father was Jairam Bhai Wadhwa at page 14, my lord. Annexure A, Lordship.
Yes, page 14.
Page 14, Jairam Bhai Wadhwa. He died on 18th August 1959.
What
Now,
is
the thesis, the subject matter.
Parsi or Wada? Wada is Hindu.
Wadhwa. Now, Lordship, the estate of Damodar Das Wadhwa, the son, Lordship, the box right at the middle, third box from the left, Lordship.
Yes.
We are concerned about his estate.
Damodar Das.
Damodar Das Wadhwa, who died bachelor on 29th of July 2022. Now, on the date of his death, only his sister and the brother's son was alive. Lordship will see from the left hand side are the brothers, two brothers, and the sister is on the right hand side of Damodar Das Wadhwa, and another sister is right at the right hand side. Now, if your Lordship sees the date of death, two of the brothers and one sister had predeceased. The surviving sister was Anushwa Pujara, and Lordship will see the son of Durgeshi Jairam Bhai, which is the second box from the left. was alive. That
Yes.
is Dilip Wadhwa, also a class 2 heir.
Class 2 heirs.
Is a nephew.
You are representing whom?
I am representing Dilip Wadhwa as on the date of the death of the deceased lordship of Damodar Das Wadhwa. I was my husband was alive. The applicant before your lordship is the widow of the nephew.
Dilip.
Yes.
Dilip.
Dilip lordship.
Oh.
Now, lordship is aware of the sections, lordship. The defect in the petition was that the heirs were not. Now, lordship will kindly take the petition that was filed for grant of letters of administration. Paragraph top, page top. Lordship kindly, before that, lordship will kindly take page 28, the genealogical table which was annexed to the application for letters of administration. That appears as annex page 28. Lordship will see how incomplete this is. I have not been stated. I being one of the other surviving class 2 heir, I was not mentioned. Therefore, the department didn't take it necessary for citing me. This was completely suppressed before the Honorable Court, and the application was made and it was granted without citing me. Now, lordship will come to page 20. In fact, the petition starts at page 17, and the relevant part which I, lordship, wish to place before your lordship, the paragraphs, start at page 20, lordship.
Yes, 20.
The said deceased died, leaving him surviving the following heirs, and only stated is Anushwa. Nobody else is mentioned. Now, lordship, thereafter, the petitioner is the elder sister of the deceased and as such is entitled to letters of administration. No reasoning, nothing given. Lordship is aware, section 263 demands specific pleadings as compared to a letter for grant of probate. Lordship, I'll take your lordship through the section. The requirements where the heirs were supposed to be mentioned who are surviving and who are part of the family and entitled or not is secondary. Now, this affidavit of assets was later, additional affidavit of assets was filed. Now, lordship will kindly come to the order that was passed by which the grant was made, which is at page 32. Supplementary affidavit filed by Anushwa Giridharilal Pujara, being the only heiress in intestacy, being one under class 2 heirs of the schedule, as contained under Section 8 of the Hindu Succession Act 1956. By way of the supplementary affidavit, the applicant has tried to demonstrate that the estate of the deceased comprises of several stocks and shares. The registered office of the companies wherein the deceased held shares are all outside the ordinary original civil jurisdiction of this court. It is therefore submitted on behalf of the applicant that this court has the jurisdiction to receive, try, and determine the instant probate proceedings. Considering the details furnished, I am satisfied that this court is authorized to exercise concurrent jurisdiction under the provisions of Section 300 of the Indian Succession Act 1925, despite the restrictions provided under City Civil Courts Act 1953. The only legal heiress as stated in the application is the applicant, and as such, there is none other to oppose this application for grant of. I was not given an opportunity to oppose. Grant of letters of administration in respect of the estate left behind by the deceased. Considering the view of the department upon complete scrutiny, the application for grant of letters is allowed by granting order in terms of prayer A of the petition subject to applicant furnishing a personal bond for a sum of rupees so-and-so with 2 sureties. Will grant it of letters. Now, lordship will now kindly come to the section 263, lordship. Lordship, before that, kindly come to section 278. Lordship will kindly take section 278 of the Indian Succession Act, 1925. Application for letters of administration shall be made by petition distinctly written as aforesaid and stating A, the time and place of the deceased death, B, the family or other relatives of the deceased and their respective residences. This is not there in the petition. The right in which the petitioner claims, that is also not pleaded. The amount of assets which are likely, which has been made, lordship, all other has been complied. Now I'm only on B and C. I ought to have been included as one of the heirs, surviving heirs. As such, the petition is defective. Now, lordship will kindly take section 263 also. Revocation or annulment for just cause. When it is just cause, the grant of probate or letters of administration may be revoked or annulled for just cause. Explanation. Just cause shall be deemed to exist where the proceeding to obtain the grant were defective in substance. Lordship, here I am submitting that because I was not included in the petition, therefore I was not cited, and I could not oppose the grant, the petition becomes defective. Now, the grant was obtained fraudulently by making a false suggestion or by concealing from the court something material to the case. Here also, it was suppressed and it was fraudulently, even the assets have been included, which I could have come and opposed. Lordship, this is also falls under section 263B. Grant was obtained fraudulently. The grant was obtained by means of an untrue allegation of a fact essential in point of law to justify the grant, though such allegation was made. Lordship, I fall under A and B. Now, D also says the grant has become useless and inoperative through circumstances. Now, here, Lordship, what has happened in the meantime, after the grant, few months after the grant, I've come to learn that Anushwa, all heirs surviving, and upon notice, Lordship, letters of administration may be granted to one of the competent heirs, or as your Lordship pleases, an independent, maybe an advocate may be appointed for administration of the assets.
Without revoking the grant, can I allow this?
Lord, as an interim, if my learned friend wishes to file affidavit in the interim stage, Lordship will file.
Show me the judicial decisions that I can.
Yes, Lordship. Will kindly now take.
That even
Supreme
for revocation, I can grant you, issue any interim order for protection of the estate of the deceased. You follow my question?
Yes, Lordship. Lordship, I'm first judgment I'm citing, Lordship, is 2022 SCC online,
2000?
Supreme Court 539, Lordship.
Just a minute. Please.
539. Now, in paragraph 4, Lordship, here the difference between a petition for probate and a petition for letters of administration has been explained, Lordship. And this has been held that the illustrations which form part of 263.
263.
Lordship, in section
Yes,
263,
Hmm.
there is certain illustrations which have been given. Since it's an old act, the illustrations are also treated as part of the section that has been held. And thereafter, in paragraph 6, Lordship, of the judgment, Lordship, as per section 263, the grant of letters of administration may be revoked for just cause. Explanation A under section 263 states that just cause shall be deemed to exist where the proceedings were defective in substance.
The same thing.
Yes, Lord.
Quotation. Yeah.
Illustration 2 under section 263 deals with a case where the grant was made without citing parties who ought to have been cited. Now, Lordship will kindly come back. I'm sorry, Lordship, I did not draw your attention to the illustration. Illustration 2 of section 260 specifically states that if citation has not
No,
been
I
made.
am convinced.
Yes, Lordship.
So far as your explanations in respect of section 263, I have no doubt.
Lordship will.
But you show me that I can allow your prayer for interim measures at this moment.
Lordship,
Because
that, Lordship, is subject to
269,
your
you please,
discretion.
you please go
Very
to
well.
269.
Yes, Lordship.
Even in contested probate proceeding, I cannot allow interim measures. If the parties are Hindus, Mohammedan, Buddhist, Sikh or Jaina, 269,
Yes, Lordship.
2. Okay.
Yes, Lordship.
So therefore, in revocation petition, can I?
Lordship, here is an exceptional
We have to show the
situation.
judicial
I
decisions.
shall.
Are you ready with those
Lordship, Lordship will allow me. I shall come back tomorrow and cite.
tomorrow?
Lordship, today, if your Lordship pleases, the day after
Come,
tomorrow,
come,
Lordship. Holiday, Lordship, day after tomorrow, or your Lordship pleases, I can come back and
May I
come
take
back
a
and.
preliminary point first? I think this application is not maintainable.
Allow her to complete.
Because maintainability generally we take first.
Then you have to argue first.
And
On
may
the-
I argue first?
Yes. We come back on after summer vacation. Okay.
I would have argued first so that she could get ready.
Affidavit in opposition?
But that is why I said first point of maintainability before I
Yes.
give
You have to take up
affidavit.
this issue, affidavit in opposition. Have you filed?
No, because this is the first time she is moving.
Oh.
So that is why I'm saying, my lord, take the point of maintainability. My lord, he hears me for 2 minutes, my lord. Then your lordship, if your lordship feels. My lord, first, this should come on affidavit, but the properties have all been administered accounts filed before this court. So there's no scope of any interim order. 4th January 2024, accounts filed. Administration complete. My lord, whatever may be, the point is, my lord, today she has made an application for revocation. My lord, it will not stand anymore because, my lord, it has already been administered. The question of revocation does not arise. Now, I am not on this also because this becomes a point of merit, my lord. I am on the point of locus. My lord, may I just show that? If your lordship then admits, then fine, I'll file an affidavit. My lord, what is her case? Her case is mainly, because whatever she says, it is only she can open those doors until unless she can show that she was to be cited. This is the point. My lord, kindly takes a genealogical table, please.
Filed by whom?
Yes. I'm not.
They are also referring to your.
They say that my genealogy table was not correct.
Yes.
I will not go into that. Let me first show this.
Okay.
My lord, I don't know how to put this because she has passed away. I'm appearing for the son because I've been served a notice. Now, my lord, kindly see his daughter is Onusha Pujara. Legal heir, class 2. Who is she? She is, my lord, Dilip Wadhwa. One step down. She's class 2, but, my lord, entry 4.
Entry 4.
That she did not say. Now, my lord, I will just take your lordship. My lord, law is very clear.
Allow her to.
Because, my lord, under the original side rules.
She will come back with.
No, because this is the first thing.
Yes.
Under original side rules, my lord, rule chapter 35, rule 9, citation has to be at the equal level. She is not at the equal level under schedule 2. And I'll just read it out.
Original side rules.
Chapter 35, since she is opposing and saying that no, that is not correct, that's why I'm making my submission.
Yes, chapter 35, page.
35, Malad has which book, Malad? The single volume, Malad? Eta ki choche eta ache?
No, single volume.
Oita nahi. Malad, it's chapter 35, rule 9, citation to rightful parties.
Just a minute, 1 minute.
Malad.
Yes, citation to rightful parties.
On an application or letters of administration, unless otherwise ordered, a citation shall issue to all persons having a right to take the grant prior or equal to that of their applicant. So it has to be either class 1 or anyone in class 2, entry 2, not beyond that. This is the original side rules.
Unless such persons have signified their consent to the application.
Yes. But if at that level, my lord, these persons consent that no, we do not have any rights, then I don't have to cite. If they don't, my lord, then I will have to cite. But who do I have to cite? Either class 1 heirs or class 2 entry 2 heirs. Not class 2 entry 4. Why? Hindu succession law. Well, kindly takes the Hindu succession law, my lord.
Hindu succession law.
Copy আছে? No. Yes, excuse me. Well, it kindly takes section 8. I'm sure that we are not opposing the fact that it is a Hindu and falls under this act.
Lordship will allow me to reply, Lord.
It's obviously. I'm taking a point of maintainability. General rules of succession in the case of males. No dispute, this was a male. But it kindly says B. Secondly, because he was not married. Secondly, if there is no heirs of class 1, then upon the heirs being the relatives specified in class 2 of the schedule. So, my lord, it will develop on class 2. Now, kindly says 9. Among the heirs specified in the schedule, those in class 1 shall take simultaneously and to the exclusion of all other heirs. Now, kindly see, those in the first entry in class 2 shall be preferred to those in the second entry. And those in the second entry shall be preferred to those in the third entry. Therefore, my lord, she is in entry 4. So she is not entitled to a citation because of rule 9. And my lord, kindly see the second schedule for once. After this, you can come back. Second schedule, class 2, my lord.
Father.
I am sons. I am the sister. 4. Anusha was the sister. And now she is 4. Brother's son, sister's son. Brother's son. Brother's son. She's brother's son.
Brother's son's wife.
Brother's son's wife now.
Brother's son.
I'm taking it brother's son. So brother's son is entry 4. Class 2, entry 4. And I am class 2, entry 2. Therefore, under chapter 35, read with the Hindu Succession Act, my lord, this application is not maintainable. After that, my lord, let her come back, my lord. My lord, if after that your lordship wants, then I'll file a affidavit. My lord.
Lordship, may I reply to this?
If you want, then very good.
Lordship, this definitely my affidavit debe to.
No, but you maintain with the lordship
Lordship,
with me, then why should I?
Lordship, this act, Lordship, is for succession.
One more thing. One of her points that properties have been added and the title was joint title. Well, this is beyond the testamentary jurisdiction. That is a point she has taken. Hence, this is also not maintainable because it's not within the domain of testamentary jurisdiction. She knows that, and she has also pleaded that.
Civil suit is...
Yes, madam, she has pleaded that. But she says that also. And jewelry has not been mentioned here. That is her take on it.
Will you come back after summer vacation?
Lordship, may I answer one point? Just for a clarification, Lordship. The Hindu Succession Act enumerates like the provisions as to how the succession will happen. Lordship, the original side rules, Lordship, and my learned friend has cited Rule 9. And Lordship, my learned friend has not placed before your Lordship Rule 5A, which is prior to Rule number 9. Rule number 9, Lordship, will kindly have a look once again. Citation to rightful parties on an application for letters of administration, unless otherwise ordered, Lordship will kindly mark these words. Now, Lordship will come back to Rule 5A. Lordship will remember in section 263, 283, Lordship, I am supposed to, in a petition for letters of administration, I am to plead who are the family members. Now, in respect to that, the original side rules, Rule 5A, Lordship will kindly take, in all applications for probate or for letters of administration with the will annexed, the petition shall state the names of the members of the family or other relatives upon whom the estate would have devolved. Now, Lordship, this read with rule number 9,
In case of intestacy.
in case of intestacy,
So then
together
let
with
us
their
do-
present place of together, Lordship, they are supposed to plead it, and thereafter with the direction of the court in rule number 9, unless otherwise ordered.
Okay, you
If
come
I
back.
pleaded, Lordship, in the paragraph, Lordship, the Honorable
He should
Court
have
will
pleaded the
direct
law.
service.
He should have pleaded the law in his. If that is the law, then you come back after summer vacation.
Very
No
well,
problem.
Lordship, I shall come back. And Lordship,
Okay.
I'll try to satisfy on the interim
Yes,
relief.
that's why
also.
I am.
I'm grateful. I
Very
shall.
grateful to you.
I shall.
The learned counsel for the propounder petitioner propounder has submitted that the instant GA 1 2024 is not maintainable. Stop. Para. The learned counsel appearing for the petitioner has submitted that the instant application for revocation is certainly maintainable in view of Rule 5A and 9 of original side rules of the High Court at Calcutta. Stop. This is the matter when?
Is your Lordship pleases, Lordship? 1 week after vacation.
1 week after vacation. 17th June.
Very good.
এই রেখে দাও, ওই বইগুলো খুব
Lordship,
কাজে
I am the applicant in the probate, the letter application for letters of administration.
You're the applicant.
Lordship, I'm
For revocation.
I'm the applicant. Yes, but
What letters? Why you are not the letters of
no, Lordship, somehow the
You're the applicant for revocation of the letters of administration.
I have said maybe I have said
propounder, Lordship.
Propound, I have
Yes,
said
Lordship, that Lordship.
that should be corrected.
Yes, Lordship, and
The
that is all
petitioner,
that I
the petitioner for the letters of administration.
I'm grateful.
It is for revocation of the letters of administration.
No. Initially, you raised the
Formality. Okay. Very good.
okay. Petitioner
Petitioner
for the letters of administration has raised that
is not maintainable.
ঠিক আছে.
Lordship, also, Lordship will kindly record that my learned friend is appearing for the son of the administratrix, because administratrix is no more alive.
আচ্ছা ওখানে লিখে দাও
He was not
the son of the
petitioner is nowhere.
the petitioner না বলে the petitioner for letter of administration না বলে ওখানে লিখে দাও the son of administratives.
Yes.
তারপর ওইটা লিখে দিন has raised the issue of maintainability. Okay. In this fashion I have started.
Administratrix has expired in the meantime.
No, ওইটা না ওইটা petitioner জায়গায় ওইটা লিখে দিন
And all another procedure submitted that the instant application for revocation is certainly maintainable.
the petitioner means মানে petitioner for GA1. The petitioner in G1. Okay.
I'm grateful.
That's all. Okay, না নোট করছিলাম কিন্তু কিছু লেখা হয়নি।
For hearing item number 20.
My lord, I appear, my lord, the last occasion, my lord, your lordship directed me to serve a copy of the last order, whereby your lordship directed the petitioner why the instant application for letter of administration will not be dismissed. My lord, the order, my lord, was uploaded, my lord, on yesterday, my lord. I have dispatched, my lord, but the petitioner has not yet been received.
Like 56 এর অর্ডার উপরে আছে
The learned counsel for the লিখে নাও the learned counsel appearing for Subroto Kumar Saha and Shobita Saha has submitted that he was unable to serve the notice upon the petitioner, upon the petitioner in PLA 56 of 2020.
My lord, it was dispatched, my lord, but not has been served.
No, was able to serve the was able to issue the notice only on yesterday.
Yes, my lord.
Only on
And
yesterday.
dispatched in yesterday, my lord, but not has been delivered.
Yes, but you have issued
Yes, my lord, I have issued, but not
Oh.
not reached.
yesterday. The service report has not yet reached to his office. Stop. He seeks for an accommodation. List the matter after summer vacation. একটা date দিয়ে দেন তো।
My lord, after 19 maybe, my lord. After 19th.
দিয়ে দাও 19th পর দিয়ে দাও। 20th June. Okay. Then again you have to then again you have to serve a notice. Otherwise, how can it be possible? It will become infractuous. The learned counsel is to issue a fresh notice
My lord, I like.
in terms of prayer as per direction of 16 May 2022. Because if they receive that order that the date is fixed 22nd May, it will not serve your purpose. Issue fresh notice. Okay. বলা আছে তো? বললাম last line টা? Learned counsel of such and such, ওই Mr. সাহা যেগুলো বলেছে।
20th June. Item number 21.
My application.
Yes.
But the grant is will by the mother.
Yes.
For grant of probate, my lord.
Yes.
The citation was issued. It was served to all the legal heirs. Now, there is no caveat, no objection from any side. So kindly, my lord, grant the probate, my lord, in favor of
দেখি রেকর্ডটা দেখি।
two of the daughters did not receive the citation. Then there was an order by this honorable court for publication in newspaper. That was done.
Affidavit of service
Filed. It is there, my lord.
The order, last order টা কোথায়? When was paper publication was made?
Lord, I filed the affidavit on 5th of June 17, my lord.
Then the
And
whole
even
matter.
affidavit not affirmed on 5th of June 2017. And extend the copy of newspaper.
Why this is so?
It's pending from like 2014, my lord, 10 years.
Okay, এটা একে দেখতে বলো তো, ডিপার্টমেন্টকে দেখতে বলো। I shall pass appropriate order.
My lord.
Okay, আগে দেখে না ঠিকঠাক আছে কিনা, এত পুরনো রেকর্ড করে দেবো।
My lord.
আজকেই দেখে নেয়, হ্যাঁ ঠিক আছে।
I am grateful to lord.
Yes.
হ্যাঁ এখন হয় 11:53 হ্যাঁ আপনি একটা পাস করে ডিপার্টমেন্ট থাকুস। Item number 22.
Your Lordship, I am praying for not today, my lord, in this matter, my lord.
Not today.
Not today. Item number 23.
23.
Again you have some.
This is that matter, my lord, the cross-examination was going on. My learned friend has another application on behalf of an heir. I think, my lord, that has to be disposed of now.
But it's worked its course, my lord.
Practically, it is over because they have filed an affidavit in support of caveat.
That's on record. Now, my lord, 3 procedural, my lord, directions from your lordship. Number 1, my lord, is
What happened? I have forgotten.
Yes, I'll tell you, lordship, very briefly, my lord. The probate proceeding was on its way. One of the particular heirs, though mentioned in the probate application, a son, represented by Mr. Chaudhary, he appeared and submitted before your lordship by way of an application that he has not been served at all.
Okay.
No citation has been issued. So your lordship had been pleased to pass an order. Since no one has disputed that he was a son, they have not disputed that he was not served. So your lordship had directed him by way of an order to file an affidavit in support of caveat. I think he has filed an affidavit in support of caveat. And in the meantime, my lord, I, as the one of the other heirs and caveator, I was already cross-examining the executor.
Okay.
So your lordship said, let the examination continue.
Yes.
And in the
Will be
meantime,
given an opportunity to cross-examine.
he will get a time to file the affidavit in support of
Sir, may I just add two things?
Now that application practically is over. He is just to be added as a defendant in the contentious cause title.
And will not cross order for discovery insofar as I and the plaintiff is concerned, and I won't disturb the cross examination going on. After we finish this cross examination, the first witness, my lord, I'll pray that your lordship recalls him for me to put a few questions, because that's something I missed.
I would only just add one thing. I would, if it is necessary, if my learned friend finds from the deposition,
yes, certainly, if it is necessary,
then he may not exercise that option.
Very well.
Okay,
I rely on Mr. Sen's cross-examination.
এই 12টার সময় কিছু আছে নাকি?
Yes,
12টার সময় কি আছে?
Yes, 5 minutes, your lordship have that administrator. I have to tell your lordship.
তাহলে so I shall record his.
Yes, my lord. My lord, my lord,
You are for? You are for?
I am for one of the other heirs and sons.
Lord,
Defendant number one.
this application may be disposed of, my lord.
And my lord,
So if I dispose of his application, will you problem? 6 for
My
accommodation.
lord, all orders are there already.
Your brother is not here.
Who is my
Mr. Kankani is
Very well, I'll come, my lord, whenever your lordship tells me to.
2 o'clock, brother, let us come back at 2 o'clock.
तू छेड़ दाओ आजके आज की पार भी ना very well.
Then after kindly paid, please.
After
Hey,
vacation.
আসুন। Learned counsel appearing for the
complied with your lordship's direction, my lord, on 9th May.
what direction?
My lord was pleased to
এই
direct
last order টা দেখি।
my lord, our post paper, my lord, we have done.
Oh, yes. The learned counsel appearing for the executor has sought for an accommodation. Stop. The learned counsel has further submitted that as per direction, he has handed over all papers to
Defendant number 2. My lord,
the learned
Defendant number
advocate on record of the defendant number 3. Stop. And list the matter. কবে দেওয়া কবে দিচ্ছেন?
Anytime after
18th,
আমরা কি কোনো document disclose করব?
18 June.
Yes,
18th June.
Yes, only one liberty, my lord. Liberty, my lord, to the defendant number 3 to disclose to disclose documents by the next date, my lord.
Who is defendant number 2?
My lord, me.
Here, defendant number 3. I have recorded.
My lord, my 3 or 2. My lord, my mistake. My lord, 2. I'm very sorry. My lord.
কি ওখানে কি আর ডিপেন্ড নাম্বার 3 বলেছি না কি বলেছি? ওখানে ডিপেন্ড নাম্বার 2 ডিপেন্ড নাম্বার 2 করে ওটা কি বলেছিলাম বলতো?
Learned counsel has further submitted that as per direction, he has handed over cause papers to the learned advocate on record of the defendant number 2.
এবার এটা 2
Only
so you have defendant number 2.
only
Okay.
2 orders.
You have got the all the papers. Yes. Now
Only 2 things necessary. I'll bow down to my lord, your lordship's observation. Cause title would have to be corrected to formally incorporate me as defendant number 2. Secondly, my lord, I have to, my lord, disclose.
no, they sought for accommodation for this.
I don't
Okay.
want to pressurize a
Okay.
junior.
Yes. So you have become senior.
I'm junior, more junior.
in the process.
The process.
This process for both Mr. Sen and me have been going on for 8 years.
But on that day, you have mentioned about hinted about that senior advocate.
I have not hinted anything. I have not hinted
Milord, if
anything.
may I, Milord, take 1 minute.
I have spoken
our-
about the Calcutta bar,
Milord,
the neglected bar.
Milord, may I just say this?
That is the reason, only reason I
Yes.
think.
Very,
Okay.
very important, Milord. 8 years, our names are there.
ডেটটা বলুন আমাকে নামিয়ে দিন। হ্যাঁ,
18
18 June, হ্যাঁ, আপনি- হ্যাঁ, হ্যাঁ।
Milord, 8 years, our names are there. We are not becoming. Only one reason. Lordship knows Mr. Vishwarup Bhattacharya. Because his name is not there. He is not coming forward. That is why this is
He
happening.
will get a suo moto, don't worry.
This is the reason.
এবার দেখে দাও 12টা।
Okay. 18 June.
2 minutes, sir. একটা অ্যাপিলেট সাইট একটা 12টা আছে।
কিন্তু আমার তো লেগে যাবে ওখানে।
দশটা বলছে অ্যাপিলেট সাইটটা
That 12 noon matter, may I
But
lordship?
your brother is not here.
Yes, yes. They are here. Banerjee is here. I have brought him. Get out.
12 noon fixed matter.
Yes.
Item number 15 and
I
16.
have handed over to my learned friend a chart showing the actual.
We are disputing the chart, but then, my lord, for the present, since this is an interim workable arrangement without prejudice to the rights of the parties,
I don't know, your lordship.
No, you go through and
I'll tell you, lordship, why. They sent us a chart. In terms of the chart, they say that there is no rental income in respect of flat numbers 5 and 6, which is Elgin Suites, which is a portion of the premises from which, my lord, a business of letting out for the purpose of guest house is being carried on. Now, in their affidavit, they initially said, there is one affidavit on record, and I can point out that this business was also run by the deceased, originally run by the deceased.
You have never said
Yes,
that.
yes, that's on oath. That's on oath.
Should
I can
check
show.
it.
I can
My
show.
specific
Show
case
that
is
affidavit.
that this is a
Subsequent, I'll tell you, lordship.
business which was not in existence by the at the time of the deceased.
so you are not accepting this chart.
No, I am not accepting this chart.
Let
I
us
am,
come
I
back
am,
after the
I am
vacation.
not accepting this chart. What I am humbly submitting is this, because this was an interim workable arrangement.
Your lordship never said it will be an interim arrangement. Your lordship said
We
the
try
matter
to,
will be
we try.
disposed of.
No, but you can't.
Matter will be disposed of.
No, no.
That was the understanding.
No, no, no.
Otherwise, why will
How would that be the understanding?
Then why
The matter was
No,
being heard.
they have to prove their case.
Yes, that will be done in the will.
That is the will. but
As
this
far as my
application
application for
disposed of.
my
That was
application
the
for
lordship's view,
administration,
that if we are going to keep 25% set apart, the application can be disposed.
application won't be disposed of. There are so many
25% of what?
25%
All the accruals.
all the accruals.
Exactly,
Yes.
all the accruals.
They are saying they're all the
Accrual.
accruals.
This is not all the accruals. I will show from their affidavit. I will show
Then
from
let
their
us come back
affidavit.
after the vacation, I will also show.
Okay, because in this fashion it cannot be done because
Yes,
no rental. He is disputing.
That is
Okay.
disputed.
Disputed.
No, there is. It's on
Then-
record, Mr. If Mr. Shane,
I will show.
if Mr. Shane
The
sees his affidavit,
is not
no,
there.
no, his client's affidavit.
Asun,
Client
Asun.
says that the deceased used to carry on that business. Today he is saying it does not fetch any rent.
আচ্ছা এটা কত নম্বর হবে এটা?
Item number 50.
15. The learned counsel of the 50 তে কে আপনি
I mean,
you are
defendant number 2.
you are
He's plaintiff
I
in
am
the.
the propounder.
He's the propounder, plaintiff in the
2002 will.
contentious cause.
5/5/2021. You are the plaintiff.
Yes.
5/21.
Yes, yes.
5 of 2021, he's the plaintiff,
5 of
Mr. Shen.
21.
The learned counsel appearing for the plaintiff has handed over a chart of income,
Of rental income
of the
property.
relevant properties. Stop. The learned counsel appearing for the defendant has disputed the contents thereof. Please the matter after summer vacation. একটা ডেট দাও ওদের কনভেনিয়েন্স অনুযায়ী for further hearing or
আমি বলুন just a
you have to complete then your
I didn't, Mr. Shen, what failed from Mr. Shen's on instruction was that as an interim workable arrangement, pending vacation, this can be done. I am ready to take it.
No,
I am
no.
ready to take it.
I have also intervened
Yes.
and I have proposed.
Lordship's view was that if I keep 25% set apart, then this
And-
administrator issue can be resolved. They will go straight away to the proving.
If your lordship, my lord, recalls what failed from your lordship, even see the last order, my lord. Mr. Shen, perhaps not, Mr. Shen is busy.
No,
Other matters may be
I-
interfering
May.
with this matter, my lord, in my lord framing his ideas. If he sees, my lord, the previous order, he will see. Because this matter would have been protracted, my lord said,
Absolutely.
pending disposal of the, pending the vacation, let this be an interim workable arrangement, come up with a proposal. I came up with the proposal. He came up with his answer. His answer in parts does not match the actual facts.
এই ডেটটা বলো ডেটটা বলো কত
Pending arrangement in
13
can
June.
happen everywhere.
প্লিজ 13 জুন
13 June. My lord, kindly fix up a time, my lord, at 12, my lord, if you lordship. 12.
you are not agreeing
No,
with
your
all this.
lordship will kindly see your lordship.
No, kindly see,
It is
my lord,
said till the disposal of testamentary suit number 6 or
or
until,
until further orders. Therefore, this
So
was
how
an
do
interim.
We have expected that this will be the
Until
matter will be
further order,
disposed of.
Please come on
Yes, yes, I will come on 13th. My lord,
again we shall work on
Huh?
দুটো, অসুবিধা নেই?
No.
10 minutes.
My lords,
on, if he want 2 p.m., then 10 or 15 minutes.
Give me 15 minutes or 2 p.m. That will be it.
এই দুটো থেকে 2:15 এইভাবে লিখে দাও, হ্যাঁ, নাহলে হবে না।
এই জজ সাহেব এই করছেন, দুটোই লিখুন, 2:15টা আমি আমার থেকে করে দেবো, অসুবিধা কাইন্ডলি।
Okay.
My lord, vacation mood has set.
Okay. Hey, appellate side is one appellate side.
What I said that day, I think, my lord, it was taken in proper taste.
Will it be Lordship's pleasure, my lord, to will it be Lordship's pleasure, my lord, to take up the next matter on the original side? It will not take
Appellate side matter at 12 noon. One assigned matter.
Yes.
Yes.
In this matter, last occasion, Lordship directed to serve blood upon the learned advocate who appeared on behalf of the other side belonging the court below. He was served to speed post and track report shows that it has been delivered. And that's why affidavit of service to that effect has been prepared and being submitted before your Lordship. But Lord,
how can it be possible without the absence
by
of this?
thereof, Lord, nobody is appearing on their behalf.
Yes. What is your prayer in this case?
Lord, this is a matter relating to preemption. Lord, the preemptive petitioner is before your Lordship who lost, Lord, in the court below before the additional district judge. And my lord, that has been challenged in this revisional application.
What is your contention there?
My lord, it was that, my lord, checkered history is there, my lord. Checkered history is there that is required to be placed before your Lordship.
Yes,
And
but you have, my name is wrongly typed, not Roy, Ray. Come back after summer vacation. Okay?
Would you logically fix a date?
Yes, একটা ডেট দিয়ে দিন তো, 14 June করে দিন, 14 June. The Learned Counsel has submitted one affidavit of service. Let it be taken on record. List the matter on 14 June. 12 noon কিছু আছে কিনা দেখে নিন, নাহলে একটু সময় চেঞ্জ করে নেবেন। আচ্ছা, আমরা তো পরে দিই এটা, না না এখন অলরেডি হয়তো এর আগ হয়ে গেছে। 14 June. Okay. Yes.
At 12?
Yes. এটা আপনাদের, না?
তোমারটা চলবে
জানি জানি মনে লাগবে 2 মিনিট
হচ্ছে না?
হ্যাঁ
না থাকলে তো আবার হবে হ্যাঁ 24 for item number 24
Equal action by appears for the petition.
এই তো চললো
A simple matter, my lord, should not take much time, my lord. The bill pertains to, my lord, a deceased Mohammedan, my lord. Lordship would recall, my lord, this lordship had considered, my lord, this matter on earlier occasion also, my lord. In fact, my lord, this should have appeared under non-contentious cause. But because, my lord, the affidavits of consent in respect of all the legal heirs, my lord, are there, my lord. The only issue, if your lordship would recall, my lord, is in respect of, my lord, a matter, my lord, that's PLS 373 of 2021, my lord, where, my lord, Justice Mukherjee had, my lord, reserved the order, but I had showed on the last occasion, my lord, with the orders, that the issue is completely different. In that case, my lord, there is no consent. There is no consent from, my lord, the other legal heirs. Lordship knows, my lord, better than all of us, my lord, that a Muslim, by way of will, cannot bequeath more than 1/3 of his properties, my lord. The exception is, my lord, clause 117 and 118 of the modern law, my lord, which states that, my lord, if the other legal heirs consent to it, then, my lord, this can be allowed. But in that case, my lord, which is pending, there is no consent from all the legal heirs. In fact, my lord, the legal heirs could not be served also. That's recorded in the order, my lord. Here,
Submit written notes of argument. Okay, hey, Asun.
I shall.
The learned counsel wants to file a written notes of argument. Stop. List the matter on 14th June for submitting written notes.
Well, I shall file the written notes of arguments. Before that, I shall give it to your lordship's officers, my lord. If in 14-minute order could be disposed of, because
No.
no, my lord, I have been
And further hearing.
this
No.
matter, my lord.
For further hearing and for further hearing and submission of written notes. No, I have to record your submission. No.
Well, I'm ready with it today also. My lord, not the notes, my lord, but my
Because
the
summer
submission
vacation
of-
is approaching. It is very difficult for me because there are 2 or 3 matters are pending. I have to write judgment
has a heavy data.
in the vacation. Okay.
I understand.
So come back on 14th
I shall.
with written notes of,
I shall.
because another honorable coordinate bench is considering the same
No, my lord, no. There's
No.
a misconception of the department, my lord.
department. They are saying
Yes.
your written notes of argument will help us.
I
Okay.
see, even the department says, my lord, that if I get an order in this application, my lord, they'll be very happy because there are hundreds of applications similar to this which are pending, my lord, and all would be disposed
So
of.
that's why I want your written notes. Of
I shall, my lord.
Okay.
I shall.
Okay.
I shall.
Very good. With judicial decisions.
Yes.
Okay. Copy of judicial decision.
Yes. I shall.
Okay.
Probate matter item number 25
Not today. কেউ নেই নাকি?
item number 26
Yes.
I appear for the executor, my lord. On the last occasion, my lord has directed the deputy sheriff to affix the special citation on the outer wall of the one of the legal heir of the deceased, my lord. I'm being informed that that has been done by the deputy sheriff yesterday, I presume, my lord. And they have to file a report to your lordship regarding this, my lord. My lord's last order is on 24th of April, my lord.
Yes.
My lord, Bikasen has not yet filed any caveat to that statement.
21/5/2024. This was pasted on only 21/5/2024. That means yesterday.
Yes, my lord, I have been.
It is very difficult to take up this issue just right now. Okay. Come back after summer vacation. Okay. We shall consider.
Okay. In the meantime, if they do not file any caveat, my lord, then it will be transformed into a non-contentious cause.
The learned counsel for the
Executor, my lord.
executor has submitted a report from the department is received by this court. Stop. I have gone through the I have gone through the report submitted by the department, and it appears that a photocopy of citation has been affixed. Was affixed on the Kulap Civil Gate of the addressee on 21st May 2024. Stop. Please the matter. At a date dato 18th June
18 June.
for further hearing, and further order.
Grateful to your lordship.
12-15 fixed matter, item number 33.
My application for grant of probate, my lord, the will has to be proved in solemn form, my lord, before issuance of the special citation, because the attesting witnesses have passed away after filing of the application.
So
the witness is here.
এই ইন্টারপ্রিটার এসছে শুরু করে দাও।
এটা করি না। হ্যাঁ, আপনি ওদিকে চলে আস্তে আস্তে সে বলবে আমার পরে আপনি রিপিট করুন আমি যেটা বলছি। আমি বলুন
আমি
এই মামলায়
সাক্ষ্য দিতে এসে যা কিছু বলবো সত্য বলবো সত্য ছাড়া মিথ্যে বলবো না কোনো কিছু গোপন করবো না।
আপনার নাম বলুন।
মৌ ব্যানার্জি।
স্পেলিং বলুন।
MOUBANERJEE BANERJEE
ব্যানার্জি। বাবার নাম
কুনাল মুখার্জি।
The first witness.
Only witness.
আবির ব্যানার্জি।
Attesting witness.
Not an attesting witness, because the attesting witnesses have passed away after filing of the application. That is why the execution of the will has to be proved by someone else in solemn form in terms of the Evidence Act. When the attesting witnesses are not alive, it can be proved by someone else who can verify the execution of the will.
Originally, yeah.
Yes, that is there with your lordship's records.
পাটনা P8 পূর্বাচল। হ্যাঁ, ক্লাস্টার 11 ব্লক GA সেক্টর 3 সল্ট লেক, কলকাতা 97।
May the document be shown to the witness.
teacher.
আমি করে
ওই তো হ্যাঁ
shown page 15 of the application What is this document?
এটা will।
This is a will.
Who has executed this will?
এই willটা কে লিখে গিয়েছে?
আমার শ্বশুর মশাই।
My father-in-law had executed this will.
What is his name?
মিহিরলাল ব্যানার্জি।
Do you see any signature in this document?
Signature
হ্যাঁ,
Whose signature can you see in this document?
এখানে আমার শ্বশুর মশাইয়ের সাইন আছে, এদিকে উইটনেসে আমার শাশুড়ি এবং আমার বাবা আর আমাদের অ্যাডভোকেট যিনি ছিলেন।
I find the signature of my father-in-law, Sri Mihir Lal Banerjee's signature.
She did not utter the name. Why you are incorporating?
মিহিরলাল ব্যানার্জি আমার শ্বশুর
Why
মশাই।
you are helping?
My father-in-law, Ravamba.
And I find the signature of witnesses.
ইন্দিরা ব্যানার্জি
Indira Banerjee
এবং কুণাল মুখার্জি।
and Kunal Mukherjee.
হ্যাঁ,
How do you know their signatures?
কি করে ওনাদের নামগুলো জানো?
আমিও তখন ছিলাম ওখানে।
I was present at this place at that time.
হ্যাঁ, এখানে একটা থাম্ব ইমপ্রেশন আছে শ্বশুর মশাই মিহিরলাল ব্যানার্জি।
I find a thumb impression of my father-in-law, Sri Mihir Banerjee, in
মিহিরলাল ব্যানার্জি।
in the page.
Can you sorry,
ওটা যাবে না।
that is.
ও- ও-
But I'll put
ওটা-
I'll
ওটা-
put a separate question on this one.
She volunteers.
Yes, this is a
Just
voluntary.
volunteer বলে যাবে আর কিছু
Yes,
যাবে না।
yes, yes. Can you identify the signature of the testator?
আপনি যিনি উইলটা করে গেছেন উইল কারোকে সিগনেচার দিতে পারছেন?
হ্যাঁ,
Yes.
Kindly encircle the signature of Sri Mihir Lal Banerjee in red ink.
এই লাল ব্যানার্জির সিগনেচারটাকে গোল করুন, সার্কেল করুন।
ওটা
এটা যদি ধরে নিন, এটা যদি হয় এরকম গোল। মিহির লাল ব্যানার্জি
এটা
the witness encircles the signature of Mihir Lal Banerjee in red at two places. Page number 5.
At the bottom of the page, it appears that there is a mark. Are you aware as to what mark it is?
পেজের তলায় এই মার্কটা আপনি কি জানেন কিসের?
হ্যাঁ, এটা থাম্ব ইমপ্রেশন ছিল ওনার।
This is a thumb impression.
Whose thumb impression is it?
মিহিরলাল ব্যানার্জি।
Who put LTI?
Yes.
Who put LTI? Ask her.
Yes.
This is the most important question to prove this. Who put this LTI?
I'll ask the question.
In whose pen it has been written?
How do you know that this is Mr. Mihir Lal Banerjee's thumb impression?
করে জানেন যে এটা মিহির লাল ব্যানার্জির thumb impression.
ওই সময় দিয়েছিলেন উনি।
Is there any LTI? That means one who puts the LTI that this is in my pen. Is there any certificate? It cannot be taken. Okay. It cannot be marked as exhibit.
Very well. Well, the signature is here as well as the thumb
Okay, no
impression.
problem. That can be marked.
My lord.
Next. Yes.
Do you also
এই আনসারটা কিন্তু চাইনি। How do you know that this is Mr. Mihir Banerjee's thumb impression? এটা আনসার আসেনি।
Answerটা দিয়ে দিক answerটা দিয়ে দিক
ব্যানার্জির thumb impression.
উনি দিয়েছিলেন এটা সাইনের পরে এটা নেওয়া হয়েছিল।
That time, after signing, he had put his thumb impression.
Can you also identify the other signatures appearing at this page?
অন্যান্য সিগনেচার গুলো আপনি চিহ্নিত করতে পারছেন এই পৃষ্ঠাতে?
হ্যাঁ। বলো। এটা হচ্ছে ইন্দিরা ব্যানার্জি 1 নম্বর উইটনেস, আর এটা হচ্ছে কুণাল মুখার্জি 2 নম্বর উইটনেস, আর এটা হচ্ছেন আমাদের যিনি অ্যাডভোকেট ছিলেন স্বদেশ রঞ্জন চক্র।
The third signature is of our advocate who was engaged at that time.
অ্যাডভোকেটের স্বদেশ রঞ্জন চক্রবর্তী।
স্বদেশ রঞ্জন চক্রবর্তী।
Can you encircle their signatures in red ink?
লাল কালিতে। Actually, it should be
Blue ink. I'm sorry, blue ink.
1 নম্বরটা এনসার্কেল করতে হবে। হ্যাঁ, শুধু সিগনেচার।
Where was this will executed and signed by the persons present?
এই বিলটা কোথায় এক্সিকিউট হয়েছিল, মানে লেখা হয়েছিল এবং কোথায় সাইন হয়েছিল, কোন জায়গায়?
এটা স্বদেশ রঞ্জন চক্রবর্তীর অফিসে।
It was executed at the office of Swadesh Ranjan Chakraborty, advocate.
হ্যাঁ।
What was the mental condition of Mr. Mihir Lal Banerjee at the time of execution of the will?
মিহিরলাল ব্যানার্জির মানসিক অবস্থা এই বিলটা করার সময় কেমন ছিল?
ঠিকই ছিল।
It was good.
Do you know where are the witnesses who had attested to this will?
এখন এই উইটনেস যাদের আপনি নাম বললেন এরা কোথায় আছে?
দুজনেই মারা গেছে।
নাম কি? What are the names?
Indira Banerjee and Kunal Mukherjee.
Remy is the mother-in-law.
Yes.
Kunal Mukherjee?
Mother-in-law and father.
Father. Kunal Mukherjee, her father.
Yes. Father. Her father and the mother-in-law. Can you produce the death certificates of the persons mentioned by you in the previous question, in answer to the previous question? The original death certificates are there.
ডেথ সার্টিফিকেট আনতে পারবে?
হ্যাঁ।
Yes.
Not be this, but the witness tenders the original death certificate of the attesting witnesses.
Yes.
But may this be tendered in exhibit the document.
Yes, no problem. এই document গুলো exhibit করে দাও। হ্যাঁ, yes.
That's all.
না, date of will. When the will was executed, on which date?
বিল কবে এক্সিকিউট করা হয়েছে? কবে শৈশব?
1st December 2018.
And your date of marriage?
19th November 2003.
2003. Okay. এটা লিখছেন তো এটা? So apart from your oral testimony, there is nothing on record to show that you were present on that day. ভালো করে বুঝিয়ে দাও।
আপনি এখন যে সাক্ষ্যে বলছেন আপনি ওখানে উপস্থিত ছিলেন, আপনি যে ওখানে উপস্থিত ছিলেন আপনার বলা ছাড়া অন্য কোনো প্রমাণ নেই আপনার যে আপনি ওখানে উপস্থিত ছিলেন, সেটাই দর্শা করছে, তাই কি? ইয়েস।
কি বললেন? আপনার মুখের এই কথা ছাড়া, এই মানে ওরাল এভিডেন্স ছাড়া আর কিছু দেখাবার নেই যে আপনি ওই সময় যখন সম্পাদন হচ্ছিল ওখানে উপস্থিত ছিলেন। আর কিছু আছে ডকুমেন্ট? নেই। বা কিছু সইসাবুদও নেই, আপনার সইসাবুদও নেই?
আমার কিছু নেই।
Apart from your oral testimony, is there any document to show that you were present at the time of execution of the will? Yes, Uche. No, I have no document. I have not signed the said will. Okay. Anything else?
Nothing else.
এই will এর এগুলো মার্ক করে দাও। ফর্মাল প্রুফ বিং ওয়েব করে দাও, কি করা যাবে? ঠিক আছে, it's okay. Any other witness?
No, my lord, no other witness.
Who are the beneficiaries?
The executor is the beneficiary of the
Who
will.
is the executor? The relation between executor and this witness?
The witness is the wife of the executor.
এটা লিখে নিন, লিখে নিন। So only beneficiary, only beneficiary.
Yes, only beneficiary.
Who are the legal heirs of the
The legal heirs were at the time of the execution of the will, the legal heirs was the wife of the deceased, the son and the daughter. The wife has since passed away, which was the death certificate was proved. The son is the executor as well as the beneficiary, and the daughter resides elsewhere after marriage.
So, she has submitted affidavit of consent.
No, that is why the special citation is required to be issued. We have made that prayer.
That is the problem.
That is why this will had to be proved. Otherwise, there would not have been any.
Okay. I have no question.
My lord. Kindly, my lord, pass it.
No, not today.
No.
Very much difficult. I have given sufficient time to your Mr. Chakraborty. Accommodation, at least 5 accommodation.
Yes.
No, I have to then go through the entire record. Okay. লিখে নিন, এটা অর্ডারটা লিখে নিন। The witness such and such is examined. নামটা লিখে দেবেন, হ্যাঁ, উইটনেসের নামটা লিখে দেবেন। Witness such and such is examined. Stop. Certain documents have been marked as exhibits. Stop. The witness is discharged. Stop. Please the matter after summer vacation.
The department to take necessary steps in pursuance of this.
What? I have to pass order. I'm not passing the order today.
Very well. On the next.
I have to consider.
Yes, madam.
Okay. And you have to convince me, because so many revocation petitions are coming before me. Okay. I have to consider everything.
Yes.
Come back after summer vacation.
My lord.
At a date দিয়ে দাও।
17.
দিয়ে দাও। 17 জুন। ভালো দিন। ঈদের দিন হবে ওটা। No.
I'm grateful.
Yes.
আচ্ছা,
হ্যাঁ, সাক্ষী ছেড়ে দিয়েছি, ডিসচার্জ করেছি।
পেপারটা হ্যাঁ এগুলো দেখিয়ে দাও পেপারটা।
না,
আইটেম নাম্বার 27।
I am executing. I am appearing on behalf of the executor, Your Lordship.
Sir, I am appealing for the creditor's defendant. Last occasion, Your Lordship was pleased to pass an order regarding framing issue in the immediate inspection discovered. What has happened? One day delay has been done. Let another day for framing of issue may be fixed. And in the meantime, we have also.
Both of you.
On behalf of the plaintiff, I believe that the defendant has already prepared the judge's report. Let that be accepted. And
Before discovery inspection is not over, how can he? Okay, the learned counsel for the defendant.
Active documents is.
Okay, deal. A judge's brief.
And Mala judicial document also prepared.
You are appearing on behalf of defendant. You are plaintiff.
Mr. Dotto is also on behalf of the plaintiff. Who is on?
Yes, tell me, Mr. Dotto.
Yes, Your Lordship, this is we had already filed our judge's brief of documents. Since no discovery inspection was conducted by the defendant, Your Lordship. Now it is up to Your Lordship to accept the documents sought to be relied upon by the defendant. And if Your Lordship feels so, may accept the judge's brief of documents sought to be submitted on behalf of the defendant. That is it, Your Lordship.
But inspection of documents relied upon by the plaintiff, that is also required. That they have not given.
That we had offered. They had not opted for the inspection, Your Lordship.
So go for inspection and then come back.
As you know.
The learned counsel for the defendant has sought for an accommodation since he was unable to inspect the documents of the plaintiff. Stop. The discovery and inspection of the documents be completed within 3 days.
Your Lordship, if I may interject, perhaps if I have not conveyed correctly, Your Lordship, we have already filed the judge's brief of documents. I am only praying, if Your Lordship considers, let the defendant also file their judge's brief of documents, which they want to rely upon. In the meantime, we will give inspection. We will take inspection of the documents of the defendant, Your Lordship. Let Your Lordship kindly fix it for framing of issues, and we can proceed.
কি বললাম প্রথম থেকে হ্যাঁ ব্যাস আর কিছু লিখতে হবে না বাকিটা কেটে দিই The learned counsel for the plaintiff has submitted that both the parties will inspect the documents of each other. In the meantime, stop. Judges' briefs have been prepared and they may be submitted before this court. Okay.
We have already submitted, Your Lordship.
We have given the copy today.
Okay. Let the judges' briefs maybe taken, be taken on record.
As well as affidavit documents also.
List the matter for framing of issues on 19th June. Stop. The defendant is directed to inspect the documents of. So you have inspected their documents? No.
No, we have offered.
Parties are directed to complete the inspection of documents in the meantime. Okay. Okay.
Grateful, Your Lordship.
19 June, Malad.
19 June. In the meantime, you have to.
As well as. Yes.
19 June for framing of issues. For framing of issues.
Grateful, Your Lordship.
Item number 28.
My lord, in item number 28, I am appearing on behalf of the plaintiff, Your Lordship.
My lord, I appear on behalf of the defendant. My lord, what I am praying, my lord, Your Lordship, kindly take up after vacation, my lord. In the meantime, I shall, my lord, submit suggested issues.
Please fix for framing of issues.
I am ready.
I am ready with the
I am
suggested
also
issues.
ready. I can frame the issues. I have given you liberty. Your suggested issue will not do anything for me. Whatever it was, learned counsel is seeking for, learned counsel for the defendant has sought for an accommodation. Stop. List the matter 19th June for framing of issues.
Yes, 19.
Okay.
My lord, may I just file the judge's brief of documents? It is ready, Your Lordship.
Yes. Judge's brief of document filed by the learned counsel of the plaintiff be taken on record. Okay, na? Copy served.
Yes,
Copy, sir.
এটা একটু আগে লিখে দেবেন
Item number 29.
Is my application.
Here, my lord, I am
It's fixed for framing of issues.
Yes,
No,
my lord.
yet it was fixed for framing of issues, my lord. In by that order, which your lordship will find at the last page of my application. I'm sorry, on page 32 of my application.
Then
The lordship had directed discovery and inspection of documents, and thereafter framing of issues. This is the point in which this has become difficult for me to provide inspection of my documents and to take inspection of their documents, because my lord, the premises in which my documents are kept, that has been taken possession of by a receiver appointed by the Debts Recovery Tribunal.
Oh,
There, my lord, the Debts Recovery Tribunal has appointed a receiver upon the premises in which that is my office, where all my documents are kept. So I am not in a position to offer inspection of my documents because the receiver is in possession. Well, that is why in this application I have prayed for appointment of a special officer, so that the special officer can work in coordination with the receiver appointed by the Debts Recovery Tribunal and grant access to both the parties to be present, take out the documents, have inspection at that place, and then the process of discovery and inspection may be over.
My lord,
That is my prayer.
I am opposing this application, my lord. The order was passed by the Debt Recovery Tribunal. The receiver has been appointed. Instead of taking steps over there, how can they come before the High Court and ask for a special officer to be appointed for the purpose of taking inspection of the documents?
hey, why is the petition? This is the petition.
Yes.
We have already filed an opposition as well as a reply has been filed by them.
Yes, affidavits are complete.
Affidavits are
He
complete.
is trying to supersede.
Yes.
That is their only point, that I am trying to
Because the
overreach.
order was-
May I
they
submit?
have
May I
ordered-
sub- Their point in the affidavit in opposition is that I am trying to supersede or overreach the orders of the Debts Recovery Tribunal.
Yes.
Lordship will kindly record it in the order that I have no intention of doing so, and it is not even no averment has been made in the application. I cannot overreach the order of the learned
If
Debts
the
Recovery
receiver had
Tribunal.
been appointed by the DRT, they could have moved an application before there. Instead of doing that, they had filed a civil revisional application. They did not get a stay. They themselves have.
They are not parties to that proceeding. Are you parties to that?
Yes, my lord, I am a party to that proceedings. But my lord, only problem is, my lord, if I approach the Debts Recovery Tribunal, the Debts Recovery Tribunal will not grant me leave to grant me or the receiver leave to open the premises, so that the discovery and inspection pending before this court
Go
can be.
there and get the order of rejection, then come back and I shall allow.
Reject, my lord, I can't even approach the DRT for setting aside of the appointment of the receiver. That is not my position. This is not even my submission. What my lord, for the expedition.
For this prayer, you please make their before the tribunal or Debts Recovery Tribunal,
my lord,
and they will reject your prayer.
But
then come back, I shall allow. That is the
but
only.
instead of doing that, my lord, may I only submit?
Can I direct the receiver appointed by the?
No. My lord, lordship cannot direct a receiver appointed by the Debts Recovery Tribunal to act in accordance with this order.
Yes.
That is why, my lord, I say, my lord, if your lordship kindly considers that if your lordship appoints a special officer, and the special officer may do so with cooperation and coordination with the receiver appointed by the Debts Recovery Tribunal, subject to any leave or any order permitting the receiver appointed by the Debts Recovery Tribunal is granted by the Debts Recovery, the DRT. Subject to any leave granted. So lordship will not.
No, what is your problem? What is
The order was passed by the Debt Recovery Tribunal for appointment of a receiver.
Yes.
They filed it from that order. They had filed a civil revisional application. They did not get a stay. In order to by backdoor, they are coming here and saying that they want to appoint a special officer for the purpose of inspection of those documents.
So how can it be possible for ma'am?
They could have moved before the DRT. They did not do so. Not even a single application. They have annexed the application that they made an effort to, before the DRT, they made an application in order to remove or for the access of those documents. Have they done so? Not even a single application have been annexed with their petition.
But
not even the reply. Nothing.
In
What
answer,
have they done? They have done nothing.
in answer, may I only say this: the DRT cannot pass an order enabling the parties to complete the process of discovery and inspection in a proceedings which is pending before this court. Neither can this court pass an order on a particular receiver appointed by the DRT. And if I go and make this prayer before the DRT will say that DRT doesn't know what is happening in the High Court or in any other collateral proceedings.
Have they uprised the
DRT will not have any
They have done
jurisdiction.
nothing. Then
What is the point of approaching before a particular court which does not have any jurisdiction? to pass any such order. That is why I've come before your lordship, since the proceedings are pending before your lordship. Lordship can pass as, can appoint as, subject to the leave granted by the DRT.
Subject to permission.
My lord, let them have they approached the DRT with this separate?
Only after
Have
this.
they approached the DRT? The order was passed on 12th of March 2024. Now we are in May. Have they approached the DRT? They have done nothing. Now they're filing an application and stating that they want to appoint a special officer. How can they do that?
This application was filed in the month of April.
In this matter, you are the caveat or caveat?
Caveat.
Matter will be dragged. Matter will be dragged.
That is why, in order to expedite the process of this suit, I
Reject this
make this.
application. Madam. That's my humble prayer.
That
because
is, this is
they-
the malafide. This is where the malafide is.
Instead of
They will not allow me to inspect my documents, offer inspection of my documents, and they will merrily go on with the suit.
You inspect.
I
your
will
document.
inspect. I have no hesitation.
She will not inspect your document.
That is where I will be prejudiced. That I have documents to produce in support of my affidavit in support of the caveat, and I am entitled to produce that. Only difficulty is that the papers are lying in my office. The DRT or the creditor who had initiated the proceedings before the DRT does not have any right insofar as the documents are concerned. The creditor will have right over the property. The documents are mine. I don't even want to enter the property after the process of inspection is over. And the code, lordship knows it very well, the code provides that inspection can be taken elsewhere. Specifically provides. So there is no there should not be any difficulty of my learned senior friend to come and take inspection.
Instead of apprising the court before the DRT and making an application, they can't come before this court, before this honorable court and ask a special officer to be appointed. They have an annex, a single application or order of the DRT stating that they have that has been rejected or something like that.
How can I make an application before the DRT?
This court an order.
Two parallel proceedings will go on.
Appointed.
I'm not objecting to the appointment of the receiver. I cannot before this court. I do not understand what is the difficulty of my learned friend to take inspection.
Stay from that order.
Let may I pose this question to myself: can there be any difficulty on the part of the plaintiff's advocate to take inspection of my documents in a premises which is owned by me? Can there be any difficulty? Can there be any bar?
Let them approach there.
That is what I'll do if your lordship is kind enough to appoint an officer subject to the leave of the DRT. I will approach the DRT.
This is a delay tactics.
I'm filing this application to speed it up, and the allegation is I'm delaying.
You did not move.
Then lordship will kindly adjourn this matter, sanitize till I can take a leave from the DRT. That will delay. That is what is happening.
The learned counsel for the defendant has sought for accommodation. At least the matter on 19th or 20th June.
The difficulty, I'll tell you, lordship. The DRT, even if I approach the DRT will not.
I told come back 20th June. I shall consider your matter. Today, before summer vacation, it is very much difficult for us. Okay, 20th June. Okay.
Great.
Item number 30. Item number 30.
No, not today.
Not today. Item number 31.
31 and 32, my lord.
Are being taken up analogously, my lord. For the defendant caveator, the only legal heir of the deceased testator, my lord. Very good.
Last occasion, your lordship directed to complete the
discovery inspection has been completed.
Framing of issues.
No, my lord. In the meantime,
admission and denial is required, my lord. Yesterday, my lord, they give the inspection.
Affidavit of
admission and denial. Let there be direction that the affidavit of documents with the judge's brief of documents and the affidavit of admission and denial to be filed in the next statement. That's all I'm saying.
In both the matters.
Both the matters.
Analogous, my lord. Last occasion, your lordship passed the order. Both matters will be served.
Now, deceased testator had two separate wills for two separate properties.
The learned counsels of the parties have submitted that the process of discovery and inspection of documents have been over. Stop. The affidavit of admission and denial along with judge's brief
Judge's brief of documents and affidavit of documents, my lord.
Along with affidavit of affidavit of admission and denial, comma, affidavit of documents, and judge's brief.
Judge's brief of documents, my lord.
Judge's brief of document be filed after summer vacation.
My lord.
After date দিয়ে দাও তো to release the
Preferably,
matter
it will require some time, my lord.
Some time,
Preferably,
my lord.
it will require
Yeah,
4 weeks
July.
after.
in the month of July,
My lord.
2nd July করে দাও.
Second July.
I'm grateful, my lord.
Release the matter on 2nd July.
Second July.
I'm great. আমি পেয়েছি।
এই নামগুলো কি? আচ্ছা একটা সময় একটা
না না, আর কি আছে? আর কিছু নেই? সব হয়ে গেছে? বাহ। দেন ওয়ান পেমেন্টে বসে স্কুল ঠিক আছে। চলে গিয়ে ওরা 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 একজন কেউ থাকলেই হবে। আপনি একা আছেন নাকি? ও ইয়েস
1 p.m. fixed matter item number 16 and item number for the
we have to wait for 1 p.m. What is the matter?
Well, here they have,
You are appearing on behalf of?
we are for the persons who have filed the execution application for execution of an award.
Oh, execution of an award.
And
So you have to wait for till 1 p.m. because your brothers are not coming.
both sides are here, Lordship.
Yes, if both sides are here, then I can start.
We can start.
Yes, then it will be helpful for us. So you are appearing along with Mitra.
My lord, Mr. Anindo Mitra is appearing in, my lord, one of the matters. I am
Yes.
appearing in the second one. There are two, my lord, applications in your lordship's list. My lord, both pertain to, my lord, the same award. And my lord, the same award has been put in execution by my learned friend. My lord, our defenses, my lord, to this are twofold. One is, my lord, subsequent to the passing.
You are for the judgment data
Yes, my lord, about death.
in both the matters.
Yes, sir. It is the common award. Both matters, my lord, arise out of a common award.
Oh, common award.
Two separate execution applications.
Award, arbitration matter.
Yes, ma'am.
But arbitration matter, I have no.
And execution from arbitration.
Execution from
That is what they.
No, I have no determination, I think. Hey,
I am told it is specially assigned.
specially assigned. Okay, then I have to take up. Yes.
My lord, may I just tell your lordship, my lord, in just one, my lord, Mr. Mitra is in the, my lord, first matter.
So all parties here.
আমি ঠিক আছে।
And another Mitra, your friend is missing. Another friend, another Mitra.
Today, his friend is not here. I think ছিলেন তো আপনার কথা বলছিলেন মিত্র কোথায় আপনার আজকে আপনার মিত্র নেই
Yes, what happened?
Well, this is a petition
Tell me in a nutshell.
for recording.
You are for the decree
I
holder
am
or
for the petitioner.
award holder?
I am for the petitioner. And the petition is for, they have got an award, which is a majority award.
Award holder. You are the award holder. Okay.
Award, majority award holder. Majority. And this petition, after that, there has been a settlement between the parties,
Oh.
adjusting the award. So the application is for recording that compromise and order 20 rule 2 or second 47. It's the application pending and that application filed. So you want that term settlement signed by the parties, which may be filed, may be recorded as adjusting the award.
Oh.
Yeah, order 20 rule 2 and or second 47.
They are not agreeable.
But now
My lord, may I just say this? First of all, my lord, Mr. Mitra, with humility, my lord, he's much senior to me, my lord. He'll couch the prayer, my lord, in his own way, but the prayer is not that.
But I just side motive, I know that.
So, my lord,
the
this
side
application is not
modification of the
making
prayer.
file it again.
That is the prayer.
My lord, that is not the prayer, my lord.
Side motive, see the prayer. Can you see the prayer?
Hey, now.
My lord, they, as a matter of course, are asking that the terms of settlement entered into outside the jurisdiction of this court should be recorded as binding, my lord. That cannot be the case. And my lord, we are not agreeing, my lord. We have not taken the money. We have not even taken any of the bank drafts. They are trying to enforce this agreement on me, my lord. That cannot happen in an order 21 rule, even if it is.
Anyway, if
So,
you want
Malad,
to say that point,
let me file an affidavit where I have to in this.
very well. If that is a technical, an order be made, written, recording term settlement, date is such and such, 16 February, as adjusting the award.
So he's telling that it is outside the court, outside the court.
This is outside the court.
Which one?
Out of
Terms
court.
settlement are outside the court. Whatever he's showing, it has been, he says it's executed outside the court. Terms of the court.
No, outside the court can be accepted if you certify.
Yes, and Malad, there are two provisions. One is I certify. Second is he has to ask me to show cause why I'm not certified. That is not the
One simple answer, execution case, I'll file in this court.
Yes.
And in that execution case, you are filing this.
There,
that is the prayer B.
He wants to file an affidavit in opposition.
Maintainability point open.
What mean on what
I'll
ground?
point here, Malad, 2 points, sir. There are 2 points. One is, Malad, we must first appreciate whether Order 21 Rule 1 and 2 will apply in an arbitration execution.
Okay.
Because, Malad, under the code of the Arbitration Conciliation Act, Malad, it only takes over the execution part for decretal purpose, for execution.
Very
but
good.
it does not include the CPC as such.
Very good.
That is why, Malad, Section 47 also, Malad, there are lines of judgments. There's Section 47 also not maintainable. So, Malad, I'll take this point and Malad, I'll file an affidavit.
This point is a purely question of law, can be argued.
Yes, so
They may argue
Malad, I'm
anything.
only saying that there is again a Malad knows, my learned senior friend knows better. There are judges who say if you do not take this, after
But
affidavit,
no,
you
no,
cannot
no,
take
I'm
it.
not saying.
So that's why I'm just taking
I'm
this
saying, I'm humbly submitting to Lordship and to my learned friend also. This is a pure question of law. This can be filed without affidavit. So at the next date be fixed for hearing and.
Malad, I want an affidavit because I want to put it on record that I'm not agreeable to this. I'm putting it in with the writer that it is not maintainable. So I can come, I'm couching both the things together for.
They file an affidavit, file an affidavit in a manner they like. I cannot control that.
Yes.
But
Hey, Asun,
when do you file the affidavit?
the learned counsel for the decree holder has submitted that he wants to file affidavit in opposition against GA 3 of 2024. Stop. Let the affidavit in opposition be filed within 7 days after summer vacation.
Kindly makes it 10 days.
Why?
They are saying, Malad, 10 days.
10
Malad,
days.
first week, everyone, Malad, takes some time to roll in, Malad. Everyone is not as poor as me, Malad. I am staying back.
You are
You
poor.
don't
Going out, Malad.
Only one you had
After 10 days of the summer vacation, stop. Affidavit in reply within 7 days thereafter.
Yes. Man, the point of maintainability kept to.
Okay, that.
But kindly record.
List the affidavit in reply within 7 days thereafter. List the matter for hearing on the point of maintainability 2nd July.
2nd July.
2nd July.
Very good. This settlement.
Lordship did not have jurisdiction. 2 minutes left.
Yes, I told them that where is your another mitra? Where is your friend? I have.
Now, since it is not a question of lack of inherent jurisdiction, decision can be consented to. By consent of party matter.
Lack of jurisdiction anyway.
By consent of party, matters taken up before 1 p.m. by consent of party. It is not lack of inherent jurisdiction.
Not here. How can the consent be given on
Yes.
Junior chief.
No, junior to here.
Yes, you tell me.
তোমার গ্রাউন্ডে আমি আজকে একটা বলবো একদম
Yes, yes. That's why I told him.
One thing I may add, decision by reply within.
Within 7 days thereafter.
7 days. Very good.
Okay.
May I add for one more?
For hearing on the point of maintenance on 2nd July.
Oh, very good.
Okay.
And may I humbly have one prayer. This compromise term settlement had been signed in multiple copies, 6 or 7 copies, I believe.
Bring all these copies on that day?
Yes. Other copies were handed over to their advocate record, their Sourabh Ghosh. The previous advocate record. Sourabh Ghosh. He advocate, then within advocate record, Sourabh Ghosh was ceased to be advocate record now. We humbly for saying that Sourabh Ghosh, the director filed those terms in the before this in this court. before the registry. That's all. That original, all these are 6 original signed.
He's,
File.
The agreement is not in dispute.
No, he is not a advocate record, no.
The agreement is not in dispute. The signatures of the parties on the agreement is not in dispute. Get with the advocate record all of it. There is no difficulty.
Your Lordship will hear it on that day. On that day. You please come back on 2nd July. I shall consider everything. Okay, no problem. Enjoy the summer vacation.
Lordship may pass and what the sword of ghost may retain, hold the document until subject to order of court. Sword of
Mr. Anindra Kumar Mitra, senior advocate, has submitted that erstwhile advocate on record of the award holder
The award holder in item number 17.
in the
Right? The award holder in disbursement.
in the item number 17.
PC 76 of 2021.
But same order is covering both. Same order.
Retained and received multiple copies of agreement.
The terms of settlement dated, terms of settlement.
Multiple copies I have written.
16 February 2024.
Okay, multiple copies of agreement dated such a. Please mention the date.
16
2021. This is his submission. I just recorded.
terms of settlement.
Sir.
Yes.
Okay, this is his submission.
Hold them.
I have recorded.
Kindly have it recorded and had his
And
submission.
subject to
Because
further
on
order.
the 16th of February, my learned friend is saying it has been signed. On the 19th of February, in the order, it has been recorded that the terms of settlement is still going on.
I am showing the prayer. That is my prayer is 16 February.
That is what
My prayer.
Okay, it will not cause any problem because the
subject to further
senior most advocates are available before me.
Complete disagreement regarding agreement.
Agreement. Yes, the learned counsel for the other side has disputed the above submission. Okay.
Okay.
That's so 2nd July.
But which we admit.